For the 2021 board member certification. I wanted to provide this right away. We've taught this before, and one thing that we've done previously is that Nanny, our administrative assistant, she would email out and blind copy all of the attendees with a copy of their certificate. However, a lot of people said that that was going to their junk mail. So I think the best way to do this is if you can email Nanny once you've attended the course, and I have her email address here if you'd like to take it down. I also have it at the end too. If you email her letting her know that you attended and completed the course, then she'll make sure to give you the certificate. The certificate is needed. You can put in your name. We'll have the date in there for you of the date that the course was provided. Then you just keep that in your official records, and the certificate will be good for as long as you stay for your uninterrupted term on the board. If you do drop off the board, let's say a year or two from now, and then you come back on maybe a year later, you do have to retake the course. But for as long as you're on the board, the certificate will be good and you won't have to retake this every year, for example. So if you can take Nanny's information down, that would be great. Email her, she'll make sure to provide you with a copy of the certificate. So some of the topics and objectives, we're going to talk about operations, elections, financial issues, and then official records information. And some of the objectives are, of course, to increase the knowledge of duties and obligations and the applicable Florida statutes. We want to define the role of the board. What are your legal obligations as a board member? And then some association protection issues, and then association problems and issues that may come up. All right, so for operations, so going into this, let's talk about your governing documents. And if I were, in a live class, and I think we'll be getting back to some live classes, the good thing about Zoom, of course, is that it's very easy for you to jump in without having to go anywhere or meet up at a place. But the hard thing is that I like to kind of see the room and see how many new board members that we have, how many of you are existing board members. I think there might be a hand raise function on here. Just curious for those of you that are new board members, if you can see the hand raise function, if you want to do it, I'd like to see, okay. Yep, I see a lot of people, a bunch of them coming in right now. Okay, so thank you. Looks like we have about 92 people on here right now, and I see at least 25, 26 are at least new board members that have raised their hands. So thank you all for attending. So I want to go over what your governing documents are. Governing documents typically include your several items, and these are in descending order of authority. So I have these in the highest priority that's going to take precedence over everything else, and then going down in terms of lower hierarchy there. So your declaration, that can be your declaration of condominium, your declaration of covenants, conditions, and restrictions, depending on if you're in a condo or an HOA. That's your highest priority document. Whatever is in there, if there's something that conflicts in a lower priority document, your declaration provision is going to control. Your declaration typically contains your use restrictions, your easements that are granted, what you can do with the property. A lot of the substantive items with your community are going to be contained in your declaration. It'll talk about the ability to pass assessments, the frequency of assessments, and again, what you can do then with your property, easements over the common area that you may have, easements that the association may have. All of that is typically going to be contained in your declaration. Then you have your articles of incorporation. That's the document that's filed with the state that actually sets up your association as a corporation. Probably almost all of you are corporations not for profit. There are some instances where you can be a corporation for profit as a condominium or homeowner association, but it's really rare. You're typically as a corporation not for profit. And one of the things I'm going to touch on as we go on here to remind you as a board member is that you are operating a business. And so from that standpoint, even though it might not seem that way because everybody's paying their dues, you use the dues to pay the operating expenses, nobody's making any money off of it, it's still a business. It's a corporation, not for profit. And so you have to act that way in terms of the annual filings, having elections, making sure that you make quorum for your meetings. But really in terms of the board members making decisions, you have been elected by your members, or even if you haven't been elected, if you ran and nobody else ran and you were automatically seated, you still are a volunteer that is placed on the board for the purpose of conducting the affairs of the association. And so it's a good reminder maybe to provide to members sometimes if they are interrupting your board meetings, for example. And there's a time and a place for member comments on agenda items, but it needs to be orderly. And there needs to be a reminder sometimes of saying, hey, this is a board meeting. We need to conduct business. This is for us as a board. You've elected us. We're happy to take your comments for 3 minutes on an agenda item. But aside from that, it's on the board to decide this and make the decisions because that's what we've volunteered for and that's what we've been elected to do. So I say that just as the reminder in terms of the articles of incorporation and the fact that you're running a business. Similarly, your bylaws, those are more in line, kind of more similar to your articles in that they govern more the procedure and the governing aspects of the association as a corporation, not for profit. It will talk about the composition of the board, how board members are elected, the officer positions, the quorum requirements for membership meetings. So it's more of how the association acts rather than having substantive use restrictions or anything that you would think of in terms of what can I do with my property. One thing that I always find is that, especially if you're new to a community association or somebody that isn't as familiar with it, they'll say, well, the bylaws don't allow us to do that. And in this case, the bylaws are actually a specific term that's used for more of the operation of the board and the association rather than for the use restrictions. Probably when you say the bylaws don't allow us to do that, you're probably talking about the declaration and some of the use restrictions that are contained in there. And then the last document that's considered a governing document are your rules and regulations. What's important to note, rules and regulations, typically, the way I like to define them is they further supplement what is usually contained in the declaration. And so your declaration usually doesn't get into the nitty gritty of, okay, what are our pool hours, for example, or what are the weight limits that we might have on pets, or what about using the weight room or something like that. The declaration will talk about the board's ability to maintain and administer the common elements, but then it might have language that says subject to rules and regulations promulgated by the board. So then your rules and regulations are usually board approved. It doesn't require membership approval, but they may further supplement that and say, yes, we as the board have the ability to administer the common areas, and here are our rules in place that we have for it in terms of what can you place on your balcony, you know, all the stuff that I just talked about. But you do have to have that rulemaking authority. Just make sure that you have that and what the scope of it is. I've seen for HOAs, for example, or even for condos, it might have rulemaking authority for the common areas, but it might not have rulemaking authority for parcels or units. So when you are thinking about adopting a rule regarding what somebody may do with their parcel or their unit, make sure that you have that authority in there. It's not a statutory right to adopt rules and regulations. It's a right that needs to be afforded per your governing documents. And by and large, I would say 90+% of the time it is, but just be mindful of that. Also, I've seen some maybe older condominiums that have stated that the rules can only be amended by membership vote. If that's what the governing documents provide, then that's what's going to control. There's nothing in the state statute that says that it's just a board vote. So you do need to be mindful of what your rulemaking authority is under your governing documents before you adopt new rules and everything. We'll talk about some meeting notice requirements for adopting rules later on. But again, one of the things I see boards do sometimes in a way to avoid having a member vote is to try to amend the rules and regulations when really it's an amendment to the declaration. If something's covered in the declaration and you don't like it, but you try to pass it as a rule change, the rule cannot conflict with the declaration and control. The declaration as the higher priority document is going to control over that. And I understand why that would be sought after, because it's a lot easier to amend something by way of board vote than by membership approval. But you do need to look at what are you trying to change and what document should be amended. That's a big part of governing. The other thing I like to include in this is, and there's still some debate about it, I answer questions. I actually just answered one question yesterday for a community about this, as to whether or not your architectural guidelines are considered rules and regulations and some of the requirements for meeting notices and that sort of thing. I typically tend to lump them in. It's better to be more conservative if you're changing your architectural guidelines for an HOA where it affects somebody's unit or their parcel, and give the 14-day notice before you make those changes rather than just adopting it at a meeting that hasn't been noticed or that provides 48 hours notice. So there's some questions there as to whether or not the architectural guidelines are considered rules and regulations. That impacts also when you change your guidelines, because now for both HOAs and condos, when you amend your rules and regulations, you have to record that in the public records, because it says that any amendment to the governing documents needs to be recorded, and the rules and regulations were recently added to the definition of a governing document. That then would impact whether or not you need to amend your architectural guidelines whenever you change them. To me, I think it's a good thing to record those documents from the standpoint of it places owners on constructive notice, whether or not they look at it, but anything that's recorded for your association and it's done properly, owners and future owners are placed on constructive notice of it. So it's something to think about whether or not you should be recording your ARB guidelines. And that's something that maybe you might need a more specific opinion depending on what your governing documents provide and how your community operates, but just something to think about in terms of your governing documents and the order of priority, and then whether or not you need to record any amendments to them. Some of the things the association must do: the association must establish a budget, set aside funds for future maintenance, collect assessments to pay for common expenses, and then enforce its rules and regulations, its covenants and restrictions, and so on. So, the biggest thing, we'll talk about budget adoption. That's the best way, of course, is how do we know that we're on track? Well, you need to establish a budget. And how do you do that? You establish a budget by determining what your expenses are each year. And then if you're a not-for-profit corporation, which probably all of you are, then you need to say, okay, well, if we've got a $500,000 operating budget, that means we need to have of expenses, then we need to have $500,000 of income. And so that's how you back into your assessments. You figure out what your expenses are going to be, and then how are we going to pay for those? So the good thing with your budget is that you're not reinventing the wheel each year. Obviously, you're taking what worked from previous years. You may be, amend line items. You may add some line items for things that have popped up that you haven't budgeted for before, but you're not creating it from scratch each year. Enforcing your rules and regulations. I like to just touch on this for a moment. I get a lot of questions especially for older associations that may have use restrictions that aren't applicable right now, or the current board isn't really interested in enforcing because maybe your community has changed to the point that this isn't really something that you think that you should be enforcing. And I have, two ways that you can handle that really. One is to not do anything about it, don't enforce it. But the problem is that if there's an egregious violation that may fall under that restriction later on, you're probably going to not be able to enforce it against that owner when you try to, because you may have either waived from a statute of limitations standpoint, or from a waiver, or from an estoppel, or from a selective enforcement standpoint. Those are the main defenses to maybe a board that hasn't enforced something on one time and now wants to enforce it going forward. So by not doing anything with it, you run the risk, of course, of if there is a bigger violation down the road of that same rule, and you haven't enforced it uniformly in the past, you might not be able to do that going forward. That's one of the number one affirmative defenses that are raised by owners when you come after them. They're going to point their finger and say, how about all these other instances? Why aren't you going after them? Why are you picking on me? So that's what happens if you don't enforce it. There's a potential for an owner, a neighbor, to go after the association to say, you should be enforcing this. I shouldn't have to do this myself. There is some case law on this that unless the documents contain pretty strict mandatory language, that there still is the discretion of the board in terms of how it enforces its governing documents. Again, subject to, of course, that if you do start enforcing going forward and you have some timing issues or failure to enforce in the past, that you may not be able to. But I'm not as worried. There is the possibility, but it is possible to defend that from an owner trying to force you to enforce the documents against somebody else. So you have that potential. The other thing, of course, is just to amend your governing documents to remove that. That way you eliminate it. It doesn't come up anymore. You don't have to run the risk of an owner coming after you for not enforcing your documents. And then you don't feel like, well, do we have to enforce it because it's there, even though we don't want to? By amending it, you take that out of play. So that's the biggest thing. I think what you're going to find, especially for our new board members here, is that you're going to have owners that are going to complain and say that, this person's in violation, you need to go after them. It still is in the board's discretion as to whether or not that does constitute a violation. Probably the biggest thing that I see where there's more of a subjective nature to it is if an owner is complaining about their next door neighbor being noisy and it being a nuisance or something like that. That can be very subjective. I always recommend, if associations are really going to try to crack down on noise issues, that the board adopt some type of a rule that maybe mirrors what the local municipality has from a code enforcement standpoint. Or, some type of a decibel level, something like that, that's more objective. Because if it comes into, well, this neighbor's complaining, so I guess we got to take it up, that neighbor may be overly sensitive. It may be a neighbor that is picking battles against their, I'm sure some of you have dealt with this before. So there is a level of the board obviously having decision-making authority and in its business judgment rule that protects the board from its decision-making as long as it's reasonable. As to whether or not it constitutes a violation. Just because an owner complains to you doesn't mean that you then have to take up the mantle and then go after the person they're complaining about. You still have the ability to determine it, and a lot of times it'll be, thank you for reaching out. However, we've looked into this. The board will not be taking any action. And I like to include in there that there's a case in Florida that says that owners are able to enforce the covenants against another owner. So if a neighbor doesn't like what their other neighbor is doing, they can actually file an action against the neighbor and enforce the governing documents. It's not that the association is the only entity that has the ability to do that. So I like to kind of put that back on them. They don't like hearing that a lot of times because they like the association to spend the money on their attorney to go after them and be the ones to deal with it. But that is a potential response that you can have there. So some of the board responsibilities and what to know, you're protecting and ensuring the interests of the association at large. You need to avoid personal gains, of course. So if you're on the board, don't make decisions that are going to benefit you personally. And what I mean by that is that doesn't mean that you can't vote in favor of an amendment that you think that you're going to appreciate that you're voting in favor of, that may make your property look nicer because of some type of special assessment for, additional landscaping or something like that. That's okay. What I'm talking about for avoiding personal gains is board members that have business interests and not disclosing that to the rest of the board, and then maybe pushing a vendor that the board has a personal interest in, or probably even worse than that, some type of a kickback or something that's not disclosed to the board. There's ways that you can have a business interest and then have that business work with your association. You just need to take the appropriate steps as a board member to disclose it and not be part of any type of decision making for anything on it. So again, that's avoiding personal gains. You need to act fairly and equally. That's another big thing that I see with communities is neighbors feeling like they're being picked on. The board is going after one group of people or one section or just one person over other people. So you need to be uniform in your actions. You need to maintain the common area interests, and kind of going along with that, you want to promote rather than diminish the common area interests. And where this comes up, and I've seen some issues, sometimes I've seen some boards come in and maybe from the standpoint of trying to save money or lower dues, they may stop maintaining certain common areas or common area interests or amenities that members have come to expect or have utilized previously. And this kind of blurs the line between decision-making authority for, hey, it's not worth it for us to keep putting money into this that, let's say, for example, you have a really old, I'm trying to think of, really old gym equipment that nobody uses, and whether or not, if people haven't used it before, do we have the obligation now to spend all this money to put new gym equipment in? I think that's a proper discussion to have and not something that's automatically has to be done. But for example, like if there's a $1,000 repair bill for the hot tub and the current board says, well, I don't want to spend money on that. I don't use it. Do you use it as a board member? No. Okay, we're not going to spend the money on it. Something like that, that's a little bit more of a cheaper fix. That's an amenity that members have come to expect. There's probably an obligation there to keep maintaining that, of course. So there's no real black and white answer on a lot of this, but I've seen some associations that have taken the position of, we're going to pave this over because nobody uses it. And then they can get into trouble with that. So just decision-making authority, by and large, you need to maintain the common area interest, and you want to promote the common area interest there. I'll talk about insurance for a little bit. And this applies really for those of you in any type of community, especially for condominiums, for HOAs that maybe if you're a townhome association, or just any HOA that has common areas that are being insured and amenities like a clubhouse, a pool, and that sort of thing. So the insurance clauses that you should be aware of, you want to have law and ordinance to policy limits. What that means is that, especially if you're in an older community, that you are basically, if you need to bring it up to code, if there was some type of a catastrophic event or something, and your community, your buildings were built to the previous building code, and now in order to bring it up, it's going to cost a little bit more than what it would be to bring it back to what the previous building code was. You need to have law and ordinance to policy limits, because that will pay to bring you up to code. If you don't have that, you're not going to get the money to bring it up to what the current code requirements are. You need to have a wind-driven rain endorsement. That's pretty standard, but you need to have that, especially obviously for hurricane season. You want to have proper coverage of all structures, including your signs, light posts, the dog houses on top of the roofs, and so on. Everything needs to be scheduled. The biggest thing, and that kind of leads into the next part for number 4, is just make sure you're including everything and you're fairly reporting it. You don't want to get into something where you don't include certain structures because you're trying to save money on your premium, or you underreport the value of those, because that's where you get into number 4 is the co-insurance penalty. And the way I like to explain it is, if you have $1 million structure, for example, that's insured, but you report it as an $800,000 value, there's a 20% difference there. if there's an insurable event, there's going to be a co-insurance penalty of that 20% of what you recover. And so I guarantee you that 20% difference of the payout for what the carrier has to pay you as part of an insurable claim is going to far outweigh whatever your premium would have been if you would have properly insured it to the $1 million value. That's kind of a simplistic way of explaining that. But the main point is make sure that you're properly insuring and you're properly valuing your structures. And then you want to have replacement costs on everything. That's actually a requirement in the Condominium Act. Replacement cost means that it actually means to what it is to actually rebuild it, not to what it was with depreciation. If you have actual cash value, it's the replacement cost less depreciation. So obviously when you're rebuilding something, you want to have enough money to actually rebuild it and not just to what it was before or what the value of the building was. So you need to have replacement costs on everything. You typically need to bring insurance claims within 3 years. So, we send out as a firm to all of our clients last fall when it was at the 3-year anniversary. I hate to use the word anniversary for that, of Hurricane Irma, for example. That was in, I think, September or October of 2020, then would have been the 3-year mark. So if you had some type of an insurable event, you typically have a deadline of 3 years to bring that claim. So be mindful of that. And then for construction defects, this again applies similarly to condominiums, to townhomes, where the association has the maintenance obligation over the townhomes and the common area amenities. And then maybe for large single family HOAs that have a lot of amenities like clubhouses and so on, you can bring construction defect claims against the responsible parties, whether it's the developer, the contractor, the subcontractor, the professionals like the engineer and the architect. You have 2 different time periods, really. The statute of limitations, that probably you've heard that term before. It's a 4-year period that runs from when you knew or should have known of an issue. The problem is that a lot of construction defects are what are called latent defects, which means that you don't really know on the surface that there's a problem there. And so that 4-year limitation might not run until really maybe you're doing some repairs or you really see some manifestation of something on the exterior that tells you that there's something wrong behind it, right? So that 4-year period it's very fact intensive, but the 10-year period, it's called the statute of repose. I call that the drop dead date. 10-year period is maybe you weren't aware you were doing some repair work 15 years after your building was built, and then you get behind the stucco or for whatever the exterior cladding is, and now you realize that we've got some wood rot behind there. Well, there's obviously a measure of protection for contractors and parties involved with construction that they can't be exposed to claims 20 or 30 years down the road, that there should be some type of a cutoff date that associations or any party bringing a claim has an obligation to do some type of inspection so that they bring a claim within 10 years. That 10 years runs from the later of certain dates, but really is when there's a certificate of occupancy issued from new construction, or the completion of the contract, especially from a reconstruction standpoint. Again, from an initial construction, this is heavily debated as to when an owner took possession of it. And that kind of goes more the certificate of occupancy for new construction. So I bring this up that it's for newer communities, but also for older communities that may have done large reconstruction projects. You have the ability to bring these construction defect claims. You want to look at it. Our firm, we work with a number of communities. We have a lot of these cases pending right now. A lot of communities that thought that, I thought that was a maintenance issue. Well, no, it's actually a construction defect issue. You can go after the parties that were responsible for this rather than you paying for all the costs for maintaining something. And you're never going to be made whole if you don't do substantive repairs. So we can review that for you. If you want to reach out to us, we're happy to do that. The other thing I just want to touch on also with insurance, if you take a look at your budget, especially if you're in a condo association, because one of the biggest line items, especially in a condo association budget, is your insurance premium. Think about how much that impacts your budget. It's probably one of the top 3 line items in your budget there. That's why it's so important to make sure you have proper insurance in place. You're paying for it. You want to make sure that you can use it and that you have proper coverage in place. So the other thing also with insurance that I like to touch on is, especially for all of you as board members, is all of you are serving as volunteers. You should make sure that you have very good directors and officers liability policies in place, because that will protect you. It's very difficult to successfully sue you as a board member. Now, one question that I get is, can I be sued as a board member? My answer always is yes, but it's very difficult to be successfully sued. And so even though you can be sued as a board member, it's difficult to be successfully sued. You want to make sure that you have protection and coverage under your directors and officers liability policy so that the insurance carrier will step in and appoint counsel for you so that you're obviously not paying for it out of pocket if you're named personally in a lawsuit. So that's the number one thing. If I were serving on a board, the number one thing I would want to say, even just as a refresher on maybe, hey, I'm getting acclimated here. Let's talk with our insurance agent and what policies do we have in place, and do they have any recommendations on adding anything to our D&O policy, to our general liability policy, to our property policy? What do we need to have? Are we in good shape? Kind of have a checkup on that, whether it's every year or every other year, but especially for directors and officers liability policy, because that's what protects you. It protects you as individuals. All right, so some of your board responsibilities, you want to act as one unit to set policy. You need to enforce your governing documents. We talked about that before. Maintain the value of the property, conduct board and annual meetings. You need to meet frequently, whether it's at least quarterly for board meetings and then have your annual meeting, whatever the case may be, depending on what the needs are for your community and what your governing documents may require. You want to set goals for the association. What I mean by that is, I think it's good to maybe have some type of a strategic planning for your association for the year and think about, okay, we know that we have these projects that we want to get done. What are our highest priority projects so that we can focus on it? One thing is that if you try to do too much, it can lead to nothing being done as good as it maybe could have been if you could have spent more time focusing on properly vetting, doing the proper background and research on it, and then, voting on it and then carrying out whatever that direction, that project is that you have. So I think a strategic planning session is a good idea, maybe in the first part of the year, or maybe in the fall leading up to the next year when you're doing your budget season, because I think that may impact your budget as to, hey, I think that we want to enhance our landscaping. So maybe we should think about increasing our landscaping, a line item in the budget. You do that in the budget season, then you start talking about what are some ways that we can do that, maybe get some bids from your current landscaper, whatever the case may be. But setting goals, I think, are important, because having something there, then you can then look back at the end of the year and say, hey, we knew that we need to work on this common area or this item, and this is what we did. And I think that's a great way to kind of show the membership the value that you've brought and that you've had goals and you've accomplished them. And then the last point here is, of course, maintaining the association's financial stability. That's what a budget's for, operating pursuant to the budget. We'll talk more about this, but the budget also isn't the gospel that if for whatever reason, let's say it's October and you've gone past a line item in your budget, I would be hesitant to say, well, we can't do anything for the rest of the year on that because we're at our budget amount. The budget just meant to be an estimate. It doesn't mean that once you reach that amount that you can no longer go above it. If it's something that needs to be done, especially if you don't do something, it could give rise to liability. I'm always going to tell you as an attorney to go ahead and do it. You're going to have funds. It's not like at the end of the year, you're at a $0 amount, right? You're going to have money in your operating account each year that you carry over, but that by and large, you should have, your expenses should meet your income and that sort of thing. But if you need to go over by a couple $1,000s for something that can't wait, that's what you should do. So you want to operate and maintain your financial stability, but don't use it as such an instance that it prevents you from doing something that, if you don't, could give rise to liability. So that's just my kind of 2 cents on it. We'll talk a little bit more about financial issues later on. What are your legal responsibilities? Well, you have a fiduciary obligation, which is a duty to act for someone else's benefit and to act in the best interest of the association and its members. You must act with good faith, diligence, care, and skill. You have a duty of loyalty to the association, a duty of ordinary and reasonable care. That's a point I'll come back on in just a second here. And then you have a duty of confidentiality during and after your term of service. And that can be, in terms of attorney-client privilege or any type of privileged communication that you may have that are confidential. You have a duty of that confidentiality. So the fiduciary obligation that you have to your membership, it's the highest duty afforded by common law. So it means you're acting in someone else's best interest for the association, for its members. Good faith, diligence, care, and skill. In terms of ordinary and reasonable care, this is where I like to say, you just need to act as an ordinary and reasonable person would. You don't have to be an expert on this, and nobody expects you to be an expert on, from a financial standpoint, and nobody, you're not expected to be CPAs that understand everything from a financial reporting side. You're not expected to be professionals on hiring landscape architects or anything like that, or anything that may come up. The best thing is you need to just act as a reasonable person would, And the best way that you can make your decisions, in my opinion, are to rely upon the professionals that you do have. I know we have managers on here. There's a lot of great community association managers, and probably most of you have a community association management firm that you've hired. They have a license. They have to go through, and their license, they have to take continuing education to help work with community associations. Rely on your managers to help you with your decision making. Rely upon your attorney to help make recommendations on what decisions you can make. Or again, your CPA that you have, your insurance agent, all of those different professionals that you work with. I think as long as you're reaching out and you're taking the appropriate advice and then acting pursuant to that, that's why you have all the different people that are advising you. That as long as you're doing that, I think you're going to be in good shape. The problem that can come into play is if you're in a community where the board is not relying upon that, they're not acting rationally. I had one community that I've heard that I don't represent, but was going through a reconstruction project, and they had millions of dollars from a construction defect standpoint. And it was a board member's nephew that was a painter that had no history of a large multi-million-dollar reconstruction project, but that's who they hired to tear off all the stucco, to plan on how you're going to, put up a new weather-resistant barrier, make any framing repairs, and then put on either new stucco or additional siding. And you can guess how that went from them, from what I understand. So in that case, I don't know that that board acted with ordinary and reasonable care, for example. I can give this example because it's not one of my clients or anything. It's just something that I heard about. And so from that standpoint, again, rely upon the people that you've hired and that give you advice that can make your decision making. As long as you do that, you're going to be protected as board members. I always like to say in these things, and if you've been in this, you've heard me say this before, you don't need to be perfect. You just need to act as a rational person would. So even if you go through this process, you go through and you vet 3 different landscape companies and you hire one and they end up doing a bad job, that doesn't mean that you failed as a board member. It just means that they didn't live up to what they promised you and you went through the appropriate process for hiring them. So that's the best thing that I can do to tell you, is just to make sure, as long as you're going through that, you're going to be fine as a board member. And it'd be very difficult to successfully sue a board member for a breach of fiduciary duty, for example, which is the main claim that somebody would bring if they wanted to go after a board member. All right, so you want to build community. This is more practical advice. I like to say I've been doing this now going on 13 years representing community associations. And as I go along, I give as much practical advice, I feel like, as I do legal advice. So you want to build community by becoming community involved. You want to seek a positive resolution to community and membership issues. Conflict is never good as you're living there. You're living with your neighbors, right? You've got neighbor issues, you've got local government issues. You have to get along with whatever municipality that you're part of. You want to look for the win-win. Sometimes that maybe puts ego aside. Maybe you had a position before that may not be correct. Maybe you've done further fact finding or somebody's provided it to you and you want to seek a positive resolution. Probably one of the biggest things, and we'll talk a little bit later about maybe the qualities of a good and bad board member, and I'll talk about that. But seeking a positive resolution may sometimes mean putting personal differences aside to make sure that you're doing what's best for the interests of the community as a whole. You want to emphasize reasonable living and respect. Create a healthy relationship with renters. I like to steal this from my partner, Mike. He likes to say, raise your hand if you have a renter living next door to you and if you actually know what their name is. Sometimes, you'd be surprised that you realize, what? Yeah, they are. That is a renter next to me, but I have no idea what their first name is, right? I think by building that relationship, there's a couple things that go with it, but the main thing is that I hear that communities, I don't like having renters in here because they don't care about our community as much. Well, give them an incentive to buy into it, especially for longer term renters. Make them feel part of the community. Once we start having more social events, invite renters, of course, to it. Give them a copy of your governing documents. There's a question of whether or not you should allow renters to your board meetings. I tend to be okay with allowing them into it. You need to be consistent with doing that. I think that helps build maybe more of a rapport with your renters. Now, if the renters are there to complain and all they do is disrupt, that's a different discussion, right? But if you have renters that want to maybe provide insight or at least, participate as part of it, I think that just helps them buy in more to your community. And that's always important to have that. The other thing too is just from a more practical standpoint, you want to have a good relationship with the renter, because if the owner of the unit or the parcel stops paying their assessments, we do have the ability to send a letter to the tenant to require them to pay their rent to the association until the delinquency is satisfied. So just by having that good rapport, you're more likely to have them comply with that without having to figure out what our options are about going after the tenant. So having a good relationship with renters is important on a number of levels. And then establish committees. This is also, I think, I think this is good practical advice for you too. Committees are good for two ways. One is to tap into the experience that you may have in your community of people that maybe don't have the time or they can't commit to serving on the board just due to the meeting frequency or whatever else that may go into it, but they may want to help with a certain type of committee that's more focused on something they may have experience in. I think that's always an excellent idea, just to help. What that does is they're not making decisions for you as a board, but they're doing a lot of the legwork and then making recommendations. Who better to have serve on a financial committee than maybe some retired CPAs or former CFOs for their company that want to help out, and that's what they have a lot of experience in, but don't want to serve on the board. I would love to have that. I think that would be a great asset for your board. The board still makes the decision, but you have these committees that can meet separately. Then you typically have maybe a committee chair or liaison come to the board meeting, or they submit a report, and then there's a recommendation, and then the board can act on it. This is a way for a time saver for you as a board that, again, I use the expression legwork, right? They're doing a lot of the legwork for you. And some of the best run communities that I have a number of committees where there's trust involved and they have a well-established charter and kind of expectation of them. But there's a lot of respect from the recommendation there, and then the board enacts it, and then that keeps the board meetings going so they don't last too long, because now they're not having to go through all of the issues that the committee went over. The other thing too for committees, I like to say, why don't you put one of your problem homeowners that maybe comes and complains at your meeting a lot, put them on a committee, say, hey, you know what, that's a great idea. And I think that it sounds like you have a lot of ideas, and would you be willing to go out and serve on this committee and go out and research this further and come back with a recommendation to the board? Sometimes they'll say, well, that's not my job, that's the board's job. Well, no, the board's job is to also find people to serve on committees that will help, that want to help the community. It seems like then you just like to come and complain about what the board is doing, and the board is made up of volunteers, and you're not willing to actually put in the time to help find a solution to whatever issue that you have. So I have found that establishing committees and putting some of those people on it, that's actually turned into a win for the association. Some of them come back and said, hey, actually, this person now is I actually like working with them. They don't complain at board meetings anymore because they see the work that goes into it, and they've been a real asset to our community. So think about that from a committee standpoint. So what are some of the responsibilities for the board? The board's responsible to make decisions and to set policy. The board must reach a consensus on policy and direction. So again, the board is the what. I like to say the board is the what, and your manager and typically maybe your president are the how. The board sets policy, but shouldn't get too involved in how that policy is enacted. That's what you've hired your manager for, and what maybe you've appointed your president for, making day-to-day decisions on behalf of the association pursuant to that policy. So that's, again, a way where the board you find yourself having 3-hour board meetings is by the board both enacting policy and then spending way too much time on how that policy is going to be played out. I'll speak for our managers on here. And I always like to say that I'm not even going to ask them to do it, because I'll do it for them. One of the biggest thing for managers is, hey, you've hired us, let us do our job. Tell us what big picture wise you want to have done. Let us go out and help that, be accomplished for you. That's probably one of the biggest things that I hear from managers where they get frustrated in working with boards. So I'm speaking on the manager's behalf, or relaying that message without maybe it being tied to any one manager that may be on here or may not be on here. But trust the people that you work with. And so that's what I have on the bullet point here. Management implements board directives. They work with the president to fulfill the policy of the board, and they serve at the pleasure of the board. Communication with management. You want to have a shared vision between your board and your community manager. You want to agree on expectations. Understand the difference between setting policy and directing operations. You want to have action lists and monthly reports, and then have mutual respect. Big thing on action lists and monthly reports. That's a good thing just from a practical standpoint of get in the routine of having that. It's a way of kind of having some accountability, but also understanding that that's the best way for things to get done are, okay, at this board meeting, we decided we're going to do this. At our next board meeting, I want you to report on what were the results on all these items. So that's a big thing to have. You want to have some policies in place too. Some of the biggest policies that I would recommend are having a collection policy. A lot of times our firm, we help draft that. It's a great tool for us as a law firm if we need to help out with collections, but also for management, because a lot of times, especially depending on when your board meets, management may say, well, this person's delinquent, but I don't have a clear understanding from the board of when we as management can send a letter to them, when we should send it to the attorney. Establishing a collection policy, for example, might say, if you're X number of days late, you'll get a reminder notice. If that expires, then we'll send you another notice imposing a late fee. And then once that expires, we have direction to send it to the attorney to send a letter. A policy like that that's very clear cut and that's been adopted by the board helps management then, and you can be more efficient with making sure that letters get sent out timely. You're not waiting for the next board meeting. And then you as a board, you're not having to spend time on that, going through everyone, say, yes, and this, yes, then this. You know, it's already been approved because that's what your policy is. So that's a big one. Having some type of a violation policy in terms of maybe courtesy notices that are provided. That's important. We've helped draft those as well, what your finding process is going to be. So those are just some policies that you may want to talk about with your manager and what may help you better, more efficiently operate as a board. So some board member roles and responsibilities. Again, your homeowners that have been elected to serve by your peers. You're responsible for the conduct and business and delivery of service to the association. You're subject to your governing documents and the applicable laws. So here's where I want to just take a quick moment to mention the applicable statutes that are in place that govern your association. So I like to bring up, I'm from, in my accent, you could probably still hear it, I'm from Wisconsin though originally. And coming from Wisconsin, I had a vague understanding of what an HOA was. We don't have many up there. From where I'm from, there's some farmland from where I grew up. But by and large, you know, I understood maybe what an HOA is, and a lot of it maybe came from Seinfeld with Del Boca Vista Condo. And again, let me do this. Raise your hand if you remember Del Boca Vista and Jerry's dad serving on the board. Okay, at least 20 people have raised their hand. I'm glad we've got some Seinfeld fans in here. I always got a kick out of it. Like I'm moving to impeach, you know, because I think Jerry bought his dad a new car and they thought that he was stealing money. That's not that far off from some of the allegations that are made that I've seen in some of these board meetings before. But I always enjoyed that. But, you know, coming down here and realizing this and then now practicing in this and in terms of, you know, being an attorney and representing association, there are a number of statutes that are individualized depending on the type of association that you live in. There's a condominium statute, which is Chapter 718 of the Florida statutes. There's a homeowners association statute, which is Chapter 720. Those are the big ones that probably by and large, all of you in here. There's also a cooperative statute. There's a timeshare. There's a mobile home. And then you also have, so those are kind of the five main ones. And then you have, in addition to that, the corporation for-profit statute, which is 607, and then Chapter 617, which is the Corporation Not-for-Profit Act. So you have all these different statutes, but if you're in a condo association, pretty much you're going to abide by two statutes. It's the Condo Act, Chapter 718. And then if you're a not-for-profit, it's going to be 617 of the Florida statutes. For HOAs, again, it's going to be Chapter 720 and then 617 if you're a not-for-profit. Condos, the Condo Act typically has a lot more covered in it that you don't have to look outside of that as much to 617. The HOA statute has a little more, for lack of a better term, holes in the statute where you do have to go to the Corporation Not-for-Profit Act a little bit more. But I find that the HOA statute is being amended a little bit more each year to kind of have it covered by the HOA Act specifically. So you do have the governing statutes. A class for another time is when does the statute apply versus when do my governing documents apply? The true attorney answer to that is it depends. And what I mean by that is sometimes the statute will say, unless the governing documents provide, and then it'll say maybe what the approval power is for something on, right? Versus it may not have unless the governing documents be provided. It may say that at least 75% must approve this, for example. So it does depend on the certain issue. It does depend also on when the statute was amended, if it should be retroactive. There's a lot that goes into whether or not the statute controls over your documents. And that's not even something that your manager should be answering for you. And I know managers will be the first one to kind of say that, like, I can't get involved in interpretation of statutes. That's where you need your attorney, and we have to look at that for you. So I'm not trying to cop out on that. I can just tell you that it's very complex depending on what is provided for in your governing documents and what the issue is in terms of the statute that controls over it. The last 2 points, your trustees to serve on behalf of others, and then you are providing oversight and guidance to the association. So I talked about the qualities of a good board member. A strong board member has good character, strong integrity, calm judgment, a willingness to serve, is committed to the best interests of the community as a whole, has relevant experience or background, has previous volunteer service, has strong people skills, and is a servant leader. So, and servant leadership, this is actually, have this in my notes, actually coined by Robert Greenleaf, who worked for AT&T and didn't like management styles. A servant leader is somebody that is humble, doesn't have a personal agenda, is thoughtful in their approach, is respectful, is willing to give their time, and does what's in the best interest of the community. So that's what a servant leader is. The other type of board member is, you have the servant leader, but then you have a board member that has power loss syndrome. Maybe they have deep leadership skills and has had power, but is kind of ego driven and wants to be relevant again. That's somebody that gets back on the board. Maybe they're retired from their previous company and they want to get back on the board to feel powerful again. Having previous experience is okay. Just make sure you're using it in the appropriate way and you're doing it what's in the best interest of the community. Or you have the other end, which is the never had power syndrome. Maybe for whatever reason, however, whatever they did, either they're currently working, they're not working, they never were in a position of leadership and they want to get on a board because they want to tell people what to do. I've seen that before. Typically, they don't have experience serving on boards. They don't really know what to do. They have a personal agenda and then they micromanage because they don't really have the experience necessary to understand how things really should work. So again, on the characteristics of a weak board member, they are unable to put the welfare of the community first, works behind the board to run things his or her way, are impulsive or quick-tempered, has a personal or hidden agenda, puts individual interest first, has little or no experience in management, leadership, or service, is unable to work with others for the common good. So we'll go through some of the roles and responsibilities. The president is typically the day-to-day officer. The way I like to explain that is if the board has made it a policy decision, and if there needs to be then some day-to-day actions, kind of carrying out that policy, typically that's the president that works with the manager to do that. The president then, a lot of it is making sure the meetings are running properly. They call the meetings to order. They can call meetings, announces the agenda and adheres to it, recognizes members entitled to the floor, make sure that the meeting is running efficiently. So states a question, calls a vote, announces the outcome, maintains order through impartial parliamentary procedure, expedites business, is familiar with all the rules and documents of the association, and then may be able to appoint committees per the bylaws, depending. So the biggest thing, I'm going to just go into real quickly about running a meeting because I think it's important for the president. That's why it's important to have an agenda. The president typically is the one that helps make sure everybody sticks to the agenda, that they're going through the appropriate process of recognizing who's entitled to speak, going through that orderly, treating everybody uniformly. But then when there's a decision that needs to be made, it falls on the president to say, all right, does somebody want to make a motion? We've discussed this for a little bit, but does somebody want to make a motion on it, right? So then you move to whatever, I move to hire this company for this service. Then it's seconded, and then there can be a further discussion on that. Where I see where a president can be very effective is to come back in and say, hey, we've had a bunch of discussion on this, and now we're starting to drift off topic. Let's go back to what the motion is on the floor. I need to call that to vote unless there's any further discussion. If not, let's call it to vote. You do that, then you can move on to what the next item was that people were discussing there. So that's where the president really helps make sure that your meetings are running properly. Vice president typically has all the powers of the president in the president's absence. The secretary and the treasurer are the next two ones. Those are the other two officer positions, but are by and large, their duties are usually fulfilled by management that have been hired. But the secretary is the recording officer, is the custodian of records. They keep accurate minutes of all meetings, and then they sign the minutes and the other governing documents. The treasurer keeps thorough and accurate financial records. They produce regular reports of disbursement and income. They produce annual financial reports to the membership, and they submit financial records for audits and then authorize the disbursement of funds. Again, typically this is done by your management company. The manager, the scope and duties are specified by your contractual agreement. You have a management contract in place. You can take a look at that, and there's typically a scope of responsibilities there. They carry out the policies as set forth by the board. They administer the services, programs, and operations of the association. They provide information, training, and leadership. Your manager will act in the best interest of the association and keep the board informed on progress of key projects. The best managers that I work with stay up to date on legislative changes. They have their continuing education requirements. And then usually then what happens then, that education, of course, passes through so they can better help work with your community, make suggestions to the board. So that's why it's so important to have a good manager and make sure that they understand what their role is. The other thing too is just remember though that manager, they have an obligation that to tell the board, hey, This is not something that I'm allowed to do and may violate Florida statute or what they're allowed to do on their license. So just because, they carry out and they serve at the pleasure of the board doesn't mean that they do everything the board asks them to either. So just be mindful of that. All right, so let's talk about the different types of meetings that you have. You have your annual meeting that has to be held yearly. Typically, your election is held at your annual meeting unless otherwise provided in your documents. Have a review of the year and then your budget presented, depending on the time of year. If you have an annual meeting in the fall, you're going to be presenting the budget that's been adopted for the upcoming year. If you have it in the spring, maybe it's a recap of, hey, you've been paying your assessments for this, for a couple months already. Here's where the budget was based upon. That's typically done at your annual meeting. Then you have your board meetings. That's where the board conducts business. And you need to have that. The frequency is going to be defined in your documents and may say that you need to meet at least quarterly, but you can call special meetings in between then. Some boards find that they need to meet monthly or every other month. I typically recommend, I don't know, for most associations, you probably should be having board meetings at least every quarter, I would say. If you're meeting less frequently than that, my worry is that the board is either emailing and conducting business outside of a board meeting, or there is one officer that might be making decisions that should be taken by a board rather than having a proper board function on it. So that's a real kind of rough thought from my part, but I think usually at least quarterly meetings should be done. Then you can have special membership meetings that can be done. An annual meeting is a member meeting, but you can call a special member meeting, let's say the middle of the year, if you're going to vote on something, whether it's a governing document change or to waive or reduce reserves or anything else that requires a member vote. That's typically why you'd be calling a special membership meeting. You have the ability to do that. There are certain notice requirements for it. And then committee meetings. This is where there's a big difference between condos and HOAs. For condos, any committee has to operate in the same notice requirements as board meetings, which means that you have to provide at least 48 hours notice that has to be posted on the property. For HOAs, by statute, the two types of committees that have to operate just like a board does from a notice requirement is the architectural committee when they're anything to do with decision-making from an architectural standpoint, and then any committee that can make disbursements. So if you have a committee that you've allocated a budget to, for example, like a social committee even, or something like that, when that committee is making a decision that involves using association funds, that committee meeting needs to be open and noticed to the membership. Now, you still need to look at your governing documents to see if any of for an HOA, if maybe it's more strict in terms of having committee meetings noticed just like board meetings. But that's the difference between condos and HOAs. Now, what I will say is, when in doubt, just notice it like a board meeting, so that what you don't want to have happen is if there's a committee meeting where a committee can make a decision on something, but it wasn't noticed properly, and now somebody could invalidate that decision for improper notice. It's better just to have it noticed and then open to the membership so that nobody can claim that it was done improperly. That's kind of my more conservative rule. There's can be individual instances of whether or not it should be open, and we can help answer that from an individual basis for your community, but that's kind of what the statutory requirements are. So what are some of your meeting requirements? You have for quorum, it's required for official business. Any interaction contributing to the development of ideas constitutes a meeting. I like to refer to that as kind of like the barbecue rule. What I mean is if you've got, and that's not a great example with COVID and everything, but once we're done, everybody, we're getting to a better point. But when you're starting to have more social events again, where I bring that up is that if you have 3 out of 5 board members, that's deemed to be a quorum of the board. If you're discussing association business, even if you're not making a decision, that's arguably interaction contributing to the development of ideas, that would then constitute a meeting. So the way around that is to, just be mindful of not having at least a majority of the board kind of discussing something at one time outside of a notice board meeting. You could have a pair of board members talk about something because that's not a quorum. And therefore it wouldn't constitute a meeting. So that would be a way around it. So nobody expects you to, to not communicate outside of a board meeting. I get that question a lot. What about emailing? I think email, the statute does say that email is okay as a means of communication, just that you can't vote by email. I would still caution you that you shouldn't use email as a way to email back and forth about items that are going to be voted on at a board meeting, so that by the time you get to the board meeting, you've already hashed out everything. That discussion should really take place at the board meeting. So again, and then also the last thing is that for emails, just assume that emails could be made available at any time to a member that may request them, or even if you might be able to prevent it from a official records request, that if there's a lawsuit, that you may be required to produce those through a discovery. So again, be careful with using email too. My biggest thing is just try to avoid too much discussion of association items outside of a notice board meeting, just from a practical standpoint. Even from a legal standpoint, you could always ratify a decision, and usually you can probably fix anything that may have been done improperly. But what can't be fixed as easily is kind of the distrust that your members may have that the board is doing things behind closed doors and that they're being sneaky about it. That's one of the things I always hear when I attend board meetings with upset members, that they feel like the board is doing stuff outside of a meeting and they're trying to hide stuff. So that's more of a practical consideration for you. Again, your meeting frequency is determined by the governing documents. You need to provide proper notice. It depends on the type of meeting that you have. Typically, it's 48 hours notice for a board meeting. If you're having a budget meeting for a condo, that requires 14 days notice. You have to mail a copy of the proposed budget. For HOAs, you don't have that same 14-day notice requirement. You have an obligation to state that assessments are being considered. But if you're passing a special assessment, for example, that requires 14 days notice. If you're passing a rule regarding parcel or unit use, that requires 14 days notice mailed to the members. So there are different ways. You have to just make sure what your documents and what the statute require for meeting notice requirements. The last thing too, if you want to, sound smart for somebody that maybe tries challenging you at a board meeting, members always love to say, you're not operating in the sunshine. Well, you actually aren't subject to government in the sunshine, because that doesn't apply to community associations. You're not a municipality. That applies to, again, your municipalities and local governments. That's not what an HOA or a condo is. You have your statutes that govern your operation are very similar to it, but it's not the exact same thing as government in the sunshine. All right, so some quorum requirements. I'll go through some of this stuff. The membership meeting is typically a majority of the voting interests. For board meetings, it's a majority of the board. Quorum is not required for an election if 20% of the eligible voters cast a ballot to have a valid election. We'll talk about election stuff a little bit later. And then suspended voting rights don't count. So for condos and for HOAs, this applies to both. And I have it on the next slide. Excuse me. If you have 100 owners and 10 of them are 90 days delinquent in a monetary obligation, there's a process for you to be able to vote to suspend their voting rights. For condos, it has to be 90 days and $1,000 delinquent, by the way. For HOAs, it's just 90 days delinquent. You can vote to suspend their voting rights. Once you've done that, you've now reduced the total number of members to determine your quorum. So now you've gone from 100 voting interests to 90 voting interests. So that's a big difference, especially if you're trying to pass something, if you're having a vote. So I found that was helpful when, we were in the housing crisis, maybe, 9-10 years ago, when you had a lot of delinquent owners and the association was trying to operate or having votes. By suspending the voting rights, you're now able to kind of limit it down to the actual, members in quote good standing for the purposes of determining quorum and then having a member vote if you need to have a vote on anything. So that's an important tool. Talk with your manager and with your attorney about how to best implement that. For HOAs, this is one big difference, is that for membership meetings, the statute provides that it's 30% of the voting interest is required for a quorum unless a lower amount is provided in the bylaws. So this is one instance where we've given the opinion that if you have older, bylaws for an HOA that says that a majority of the members need to be there for a quorum, we've given the opinion that actually the statute would control, and that then it would just be 30% of the voting interest. Now, you could then amend your bylaws to go even lower than 30%. You can see here that would be the maximum number required for a quorum, but that you can go lower for a meeting of the members. So take a look at that. That's one of the big differences, though, between condos and HOAs, that HOAs has a 30% quorum maximum that you would have to have for a meeting, but you can go lower than that. Decisions that require a vote of the members must be made by a majority vote at a meeting where a quorum is obtained, again, unless your governing documents provide otherwise. And then suspended voting rights don't count. And we talked about that. It's the same thing for condos as for HOAs. So for board meeting attendance, it's open to all owners. Anytime a quorum is present, the owners have the right to attend, unless there's two ways to have closed board meetings. One is if legal counsel is present, that is for the purposes of discussing pending or possible litigation. That's a key thing. Just because your attorney is there to discuss maybe a potential bylaw amendment, for example, doesn't mean that you can have a closed board meeting. It has to be for the purpose of discussing proposed or pending litigation. The other way that you can have a closed meeting is if it's for personnel matters that are being addressed. There's still a debate as to what a personnel matter is. I've given the opinion that I think that personnel means an existing employee, maybe if there's performance issues, for example, you can maybe stretch that to have management, because management typically is not an employee of the association. But if you have a performance issue with your CAM, for example, and you want to discuss it, maybe that could be done in a closed meeting on personnel issues. Or if there's some type of an HR issue or a medical issue or something like that. But I would not stretch that to say, hey, we're thinking about hire new management. We want to interview the new management companies in closed session as a personnel matter. I think that that should be done in an open meeting. I don't know that that's a personnel matter, for example. Still open to debate. There's pluses and minuses. I would get an opinion if you're thinking about doing something like that. You want to err on the side of making things open to the membership so that the decision-making can't be challenged later on and then be subject to potential liability. So for condos, and this actually applies for HOAs too, that board or committee meeting participation with video conferencing, that if you can't be there in person, you can either call in or you can use Zoom or Skype or FaceTime or whatever. As long as you're there in real time, you're deemed to be there for the purposes of obtaining a quorum for a board meeting. This is one of the big things that I think is going to change though for membership meetings, is that if there's a state of emergency or under the emergency powers, that you can meet completely virtually as a membership meeting. Right now, we don't have that. You could talk to 10 different lawyers and we probably give you 10 variations or different opinions. I still have given the opinion that if you're having a membership meeting, you should have a physical location, if only for the purpose of them being able to drop off a proxy or a vote or a ballot, but then encouraging participation via Zoom so that, because of COVID and everything. But for board meetings, you are able to be present solely via telephone, telephone or video conferencing or what have you. We talked about emails before, and the statutes have both been amended to say that you can use email as a means of communication, but board members may not cast a vote on an association matter via email. The HOA statute was the one most recently amended. That was as of July of 2018. So we're coming up on 3 years on that. And I talked before about how to use email. I think it's okay to maybe provide direction to your manager to make sure that you have all the information necessary for your board meeting. But aside from that, I'd avoid emailing too much about decision-making or something that could be better discussed at your board meeting. So planning board meetings, you want to create an agenda. You want to define a purpose, create an agenda, date, time, and location, reviewing of your minutes, your reports, any committee reports, any action items, and then any new business to be considered. You want to invite the appropriate people. What that might be is if you have a bid, maybe you invite the companies to come in and present, or for the members to meet, or even for current vendors that you're working with, it might be good to bring them in every so often just to have them say, hey, here's what we've been working on. Anybody have any issues? And I think just putting a face for some of the vendors that you work with can really help. What's the best word? Kind of reduce any tension maybe with the rest of the membership if they're complaining, because now by them being there and having a face of that company where they can ask questions, they can get answers to it in real time, and then maybe have the vendor rep say, hey, that's a good question. We'll look into that. We'll make sure we address it. I think that helps, provide further trust amongst your members and the board with the people that you've hired to do work on behalf of your community. And I know that if you're inviting them, when they're not being yelled at, they're always happy to come and tell you about what a good job they're doing too. And I think by having them there and putting a face for it, I think that helps with your members understand what goes into the operation and who you've hired on everything. So some meeting hints: you want to start on time, stick to your agenda. I put Robert's Rules of Order, but really any type of a parliamentary procedure in place to make sure that you're, acting in a uniform manner and that you are, treating everybody equally and fairly for the purposes of, speaking time and that sort of thing. The key components are your motions, your resolutions, any type of debate, and then what vote you're going to have during the meeting. Your minutes, obviously your meeting minutes are an important document that are maintained by the association. They serve as the official record and they serve as the basis of an action taken by the board. So years from now, nobody's going to remember exactly what was said unless there's some type of a video or audio recording of it. They're going to look to your minutes to say, what action did the board take? So that's why it's so important to make sure that those minutes are accurately reflecting what you were doing as a board. The content of the minutes, you should have the kind of meeting, the date, time, and place, who chaired the meeting. What you're doing is you're cutting and pasting. What I usually recommend is your agenda that you posted, and then plug in what happened under each agenda item. The results of the determination of a quorum, any action taken or inaction. The biggest thing is this third bullet point from the bottom. Your minutes record what was done, not what was said. So try to keep your minutes. My challenge to you always is try to keep your minutes to one page. I know that can be difficult, but what you're doing there is you're forcing yourself to say what action was actually taken. So let's say I always like to pick on, I always give landscape. So one always comes to my mind of, new business, hiring of new landscape company, right? So then underneath that, you might say a motion was made, or maybe you put first sentence was discussion regarding the various bids that were received. A motion was made by such and such to approve the contract for this company. It was seconded. There was further discussion, and then the results of the vote were this. You don't need to go into, hey, this person liked this from this company, but not from this company. It's not a transcript of what was said by everybody. It's just that discussion took place. The problem, and the reason why I recommend that as an attorney is that you may discuss things that later on you didn't realize may have started a timer on like a statute of limitations issue, for example. And maybe not in that example from hiring a landscaper, but it might be, hey, we've noticed some cracks in our stucco. We're going to hire somebody to caulk that. Well, guess what happens if that keeps happening, and all of a sudden 6 years down the road, you realize that the cracks keep coming back because it's the underlying construction. Attorneys on the defense side are going to look at your minutes and say, well, it looks like you guys knew about cracks in the stucco 6 years ago. Why didn't you bring a claim then? You guys waited too long. The 4 years have run. So that's why it's so important to just say, maybe in that instance on the minutes, you'll say, board engage management to further look at building maintenance or something very general like that, right? So that's why be careful about what you put in there. If somebody says, I demand that the minutes reflect that I brought this up and the board didn't do anything about it, you're not required to do that. That's why homeowners are able to, and I actually have this on the next slide, they're able to record the meetings if they like. So if they want to know what was said, they can have the recording. It's not the board's job to reflect that in the minutes on everything. So owner participation in personality problems. Owners may speak on any designated agenda item. You can adopt rules. I would really recommend, if you have a lot of owner participation, that you adopt rules regarding when owners can speak and then on the agenda and how long they can speak for. The general rule is at least 3 minutes. I like having those rules in place so that do that before it becomes a big problem. If you try to enact those rules during a meeting when it's happening, I've had some members call out and say, well, where is that in place? Where are these rules? Are you just making them up on the fly, right? So by having that as an agenda item and say, hey, we're going to adopt rules regarding owner participation so that for future meetings, we have these in place. That's the best way to go. Emergency actions may be considered at meetings. Meetings can be recorded. You can adopt, again, reasonable rules regarding recording meetings, both video and audio. Some things may be that you need to tell us at least, especially for video meetings, certain amount of time in advance. You can't move around, you can adopt reasonable rules about that. Same thing for audio recordings. And then set time limits, frequency, and limit board responses. The biggest thing kind of going in with this with board meetings and how those are conducted is don't allow owners to get into a back and forth with you on a Q&A where you're letting members hijack the meeting and feel like they are entitled to answers on every question that they pose. You're not required to do that as a board. If you have a quick answer that you can give to kind of, answer it and be done with it, that's fine. But, when homeowners come loaded with, and they, anytime you see this and they start pointing their finger at you and demanding answers, you're not required to do that. One way you can do is say, hey, thank you for bringing that up. Either that's not on the agenda or we need to look into this further. We'll be sure to do that. And then we'll bring that up in the next board meeting. That's all you're required to do. Or even if you don't want to say that, you can say, thank you for your comment. If you do that a lot and that kind of sends a message across, it kind of does let them know that they're not entitled to a back and forth at the board meeting. They are allowed to speak. And the statute just says that you're allowed to comment on an agenda item. It doesn't mean that they're entitled to answers on every question that they ask. All right, so finding and suspension of use rights. I like to bring this up as kind of an operation side. And the big thing is that the board imposes the fine and then subject to approval or denial by the committee of non-directors or non-officers. So that's the only time that a committee cannot be made up of board members, is this committee that approves or rejects a fine. You have to give at least 14 days notice before a hearing in front of this committee. So the fine is imposed. You have to give them at least 14-day notice of when the hearing is going to take place, where this committee says yes or no on the fine. Once the fine is imposed, it's due within 5 days of the hearing. And then as a practical consideration, the board imposes the fine versus the delegation of fining authority. So I've had some boards that have said, hey, if we only meet every other month or quarterly, for example, but we don't want to wait each time for the next board meeting to impose a fine, can we delegate that fining authority? And I've advised that there's some potential risk for that. There's the chance that a judge or an arbitrator could say that the board doesn't have the ability to delegate that initial fining authority, and that therefore the fine could be deemed invalid. So there's kind of a risk reward to it. The reward, of course, is that you can be more efficient and get stuff out right away. The risk is that it could be invalidated versus the more conservative route of placing as an agenda item every time you have a board meeting, what are our new violations, what's subject to fine, and then we vote on it one by one. So again, that's something you should also talk with your attorney about and really consider what type of resolution and vote that needs to take place for it. But I have that as a practical consideration for you. Going further with fining and suspension of use rights, you want to consider a resolution of establishing when the fine begins. The statute just says that a fine may be imposed of $100 per day up to $1,000 in the aggregate for each violation. It doesn't say when the fine necessarily starts, except that it's due within 5 days of the committee approving the fine. So I like to have boards say, well, the $100 per day starts from once the board imposes it going forward. Or you could say that by the time the board votes on it, it would have already reached that amount, so that now the fine has reached it, or it's continuing and the board has approved it subject to the committee approval. I think that it's important for you as a community to kind of give that clear direction so that you're treating everybody the same as to how the fines are going to be imposed. And again, better to have a procedure in advance rather than reacting to a situation and making up the rules as you go there. All right, so that's the end of operations, and then we're going to jump into, that's the one for the 4 sections that takes the longest. Obviously, I know we've been going at it for more than an hour here, but it's a lot of different things that impact your community. What I'm going to do is I'm going to take a look at some of the questions because they're probably related to what I just talked about. I don't think I'm going to get to all these, but that way I can help answer these, and then we'll go forward with the next ones, ask any questions, and then I'll handle those in the same way. So a first question I have, and actually it may be more coming up for elections and recall, so I'm going to hold on to that. Steve asked, can we get a copy of the PowerPoint? Yes. If you would email us, my email address is at the end, or if you email Nanny, we'll make sure that we provide you with a copy of the PowerPoint, no problem. Steve asks, are the rules of notice the same as civil procedure when notifying units about painting and open doors? What is the minimum amount of days required for notice? So from that standpoint, I think that notice, like from a civil procedure standpoint, really is you're judged on a reasonableness as to what the appropriate time period would be if you're going to be doing something, or if you need to have access. If there's a violation that's in place, like in order, before you can go forward with arbitration for condos, for example, you have to give them a reasonable opportunity to cure. And maybe if that's what you're talking about, Steve, but aside from that, it's usually, it just depends. It's more fact sensitive as to what the situation is and what type of notice you have to provide. So I can't give you a very clear answer. It just depends. You know, you might want to give a little bit further notice. For example, if somebody's not going to be able to, you know, if you don't want them getting in and out of their unit because you're doing, you know, some type of a big painting project or whatever, give them more notice of that so they can plan accordingly from a work standpoint, or, you know, going to get groceries, but there's no, you know, hard and fast rule on that. Philip wants to know, is Florida changing laws regarding minimum rentals? Georgia recently adopted a new, I think, House bill that will restrict HOAs from restricting rental lengths. That's been in place regarding condos in terms of if you are going to amend your governing documents to limit the amount of times that can be rented, or if you're trying to extend the rental period, that it only applies to those that vote in favor, and then for future owners. There's nothing like that in place yet for HOAs. There's been discussion of that. Whether or not it's going to be successfully passed is another matter. But they've had some actions regarding municipalities, but they haven't impacted actual HOAs with covenants. You know, some municipalities have enacted something that prohibit them from cracking down on Airbnbs, for example. But by and large, HOAs are still able to vote to, you know, restrict, you know, short-term rentals, for example. Condos, you can do that, but it only applies to those who vote in favor and then future owners. So if you have, let's say, let's say you don't have any short-term rental restrictions and you want to impose a 6-month minimum rental. Let's say it even passes, you get 3/4 of the member to approve. Well, for those that didn't approve it, they still can have the short-term rental until they sell their unit, and then their future owner then is subject to the new change there. Larry wanted to know, can a board member be paid to clean the common area of an HOA? I think that's okay to do as long as it is disclosed that obviously they have a financial interest, that they don't participate in the decision-making on that. I'd want to also make sure, just to protect the association from a liability standpoint, you know, what type of insurance should they have in place? Should they sign a waiver? You know, that kind of thing. So it's kind of a similar question, Larry, of like even having homeowners volunteer, you know, to help, you know, work for the community, is having some type of a liability waiver. And even then that might not cover everything. So I think it could be possible, but there are certain steps that need to take place before the board member could be paid to clean anything. Mary Rose, I think you said, please clarify the comment. If you can kind of take that back, I'm not sure what that question was regarding. Susan says, if the condo has not established a policy, would State Condo Act prevail until the board sets policy? Specifically, an owner unilaterally installed a hardwired charging station on common property without a request to the board. Condo statute, yep, I'll talk about that later on, covers the issue. Board is now working on a policy. So in that case, if they haven't gone through the appropriate steps, they'd be in violation of the statute. You can move to remove that, and it could be a potential fine because that would be an alteration of the common elements. Now, could you do that or have them go through the appropriate steps and retroactively approve? I think that would be appropriate to do so. But that's a more individual question, but that runs into that area of there's a state statute that controls and what the owner has to do. If they don't follow it, they could be subject to a fine for that. Somebody asked, when an owner's in violation, we have to send letters to the owner. This may take several letters, which can take months before the violation can be resolved. This seems like a waste of time. Understand that. I think that part of it is just showing that you've given an appropriate, notice and an opportunity to cure it before you take violation steps. That always helps you if you have to get in front of a judge. If something requires emergency action, you are able to seek an emergency injunction from a judge. It's very limited that they grant those. I'll tell you that. But there are ways that you can do something immediately. But yes, sometimes it does take some time to send these letters, but it's important to show that you've given an opportunity to cure before you file a legal action or you start fining them for it, for example. Okay, Mary Rose's question was, please clarify the comment about options of owners suing other owners and not involving the board. So what I mean by that is that if an owner complains about their neighbor being in violation and the board doesn't think it's a violation, you can tell the owner, we're not taking any action, but you have the ability to enforce your covenants. You can go ahead and go after your neighbor if that's what you choose to do, but we're not going to do it. And there's a case that says that owners have the ability to enforce the covenants. All right, so with that, I answered some of the questions here. I'm going to save some of these for later and try to get to them later. So thank you for submitting some of these. I want to keep us going here. All right, so elections. So condo elections, and some of you probably have gone through this. If you're new board members, you probably were recently elected, for example. Take a sip here. For condos, the regular election must occur on the date of the annual meeting or as stated in the bylaws. Any vacancy on the board should be filled by electing a new board member, and the election must be conducted by secret ballot. You can provide for term limits. If it's not defined in the bylaws, then the terms expire on the election of successors. So what that means is that a couple things for term limits. One is how long is the actual term when you are elected? And then also term limits from the standpoint of, do you want to prevent a board member from being able to serve for so many consecutive terms or so many consecutive years? There's a state statute on this that there's still some debate as to the retroactive application of it, but it says that you cannot serve more than 8 consecutive years on the board. unless either you don't have more candidates than there are vacancies, or unless, you can still, even if there are enough candidates to have an election, if you received at least 2/3 of the votes for the election, then you can continue on the board there. But you can provide for that in your bylaws. A candidate must be eligible to serve on the board at the time of the deadline for submitting the notice of intent to run. And that notice of intent to run has to be 40 days or more prior to the election. So you need to be a member in good standing. And what that means is that you have to be current, you can't be delinquent, and you cannot be convicted of a felony and not have your civil rights restored for 5 years. Those are the two ways that you're not able to run for the board. Talked about this for term limits. You can have longer than a 1-year term. It used to be that you could only have a 2-year staggered term as long as it's providing the bylaws. Now you can have 2-year terms for everybody. So if you have a 5-member board and everybody's elected at the same time for a 2-year term, you are now allowed to do that. You could even go to a 3-year term. It used to be limited that you can only go up to a 2-year staggered term. And then I talked about the 8 consecutive year issue. So the process for elections, you first send out a first notice that it is provided at least 60 days prior to the election. That's kind of a call for candidates and letting them know when the date of the election and the annual meeting is going to be. Candidates must submit their name. I said that before, at least 40 days prior to the election. Then they have another 5 days before the deadline is to submit what's called an information sheet. That's like a 1-page document that says, this is why I'm running for the board and why you should vote for me. I don't ever know why they don't have those 2 time periods line up where you have to submit both at the same time. But you can submit you have to submit your name at least 40 days, and then you have another 5 days to then submit your information sheet. Then you provide what's called a second notice. That provides the agenda for the board meeting or the annual meeting. It also includes if an election is going to take place, and if it is, you include the ballots, which lists all the eligible candidates that have gotten their name in. So that's what the second notice is. And that's provided not less than 14 days and not more than 34 days prior to the time of the annual meeting. All right, so for condos, it's a pretty clear black and white. You're not allowed to have nominating committees for condos. You're not allowed to have nominations from the floor. Everybody's eligible to run, aside from people that are delinquent at the time they submit their name, 90 days, or if they are like I said, if they've been convicted of a felony and have not had their civil rights restored. So pretty black and white. You don't typically see a ton of challenges from the condominium election standpoint. Where you do see it more is from a homeowner association standpoint. And that's because it's not as, you don't have a statutory requirements like all condos have to follow, like you do for HOAs have to follow, like condos have to. So you have to conduct the election as provided for in the governing documents. So it's so important to know what your documents provide to make sure that you're operating pursuant to it. Your board of directors must be elected by a plurality of the votes. It's the same thing for condos. Talk about the ineligibility on this next bullet point. Same for HOAs as condos as to who's eligible to run for the board. And this is a big difference. So a member may nominate himself or herself as a candidate at the meeting where the election is to be held unless the governing documents provide for nominating in advance of the meeting. So this is really important that if your documents just say that the election takes place at the annual meeting and that you have to provide at least 14 days notice of the election and the annual meeting, that is not a process for nominating in advance. So anybody can nominate himself or herself. There's an association that got in trouble and they had an arbitration decision entered against them where they essentially adopted as a policy by the board the condominium form of election. But what happened was an owner didn't get their name in within the 40 days and they tried to run for the board, and I think they tried to nominate themselves. The board prevented it. And then when the owner challenged it from an election standpoint, the association said, no, we've had this policy for 10 years. The arbitrator said, it doesn't matter what your policy is, it matters what your governing documents provide. And since your governing documents didn't provide for a process for nominating in advance, you were in the wrong for not allowing this person to nominate themselves on the date of the meeting. And they ordered a new election, and that owner had their attorney's fees paid for by the association. So that's why it's so important to really say, are we holding our election in the same way that our governing documents provide for it? So really take a look at what your governing documents provide for. All right, so some other updates. If an election is not required because there are fewer or equal candidates and there are vacancies and nominations from the floor are not required, then write-in nominations are not permitted. So again, if you If you have the process for nominating in advance, this is a good thing because let's say you have like the condo form, which is what I've been recommending that clients amend their bylaws to. If you have that and only 5 people run for 5 spots, even if you don't make your quorum for the annual meeting, those 5 people still are placed on the board. That's an important change and why it's so helpful to have a nomination in advance process so you're not worried about making quorum at the meeting. Otherwise, if you don't have that nomination in advance process, and if you don't make quorum, then there are no new directors. All of the previous directors hold over until you can actually make a quorum and have your meeting. So that's why it's so important to have nomination in advance so you're not really as tied to the quorum requirement if you don't have more candidates and there are vacancies, for example. Let's see, there was a question before about recall. In a board recall election, can the board be removed, use HOA funds for their legal defense? Yes, they are able to do that. So if the board decides, so what a recall is basically, the only way that you can remove a board member before their term is up is by a recall, which is by the membership. And that can either be done by calling a meeting of the members and having a majority of the members vote to remove the director, or and this is the more common scenario, having a petition signed by at least 50% of the members delivered to the association seeking recall of the director. I've had some questions recently actually where they say, well, can the board remove a director because they're not showing up or they're not participating, or we think that they're making bad decisions or whatever, saying things to the community even. So no, the only thing you could do is you can change their position as an officer and you can remove them from a role as an officer on the board, but only the membership can remove a director by recall. Now, if a recall was not done properly, there are certain limited ways for the association to deny it. And yes, the board would be able to use legal funds from the association as part of the defense as the association. Now, if it's a board member that was recalled, that he or she feels like they were not properly, that the recall was improperly certified, they would not be able to say, I need to get back on the board and the association needs to pay my legal fees. The association may have to pay their legal fees later if that board member was improperly recalled and the board improperly certified it. But for the initial board member, they have to pay for their own attorney and then they can try to seek reimbursement later. So I hope that helps answer your question on the recall. Just note, I'm not going to go too far into it. Just note that if you are served with a recall attempt, the board's required to meet within 5 business days. And if you are going to deny it, you have to make those decisions known within that board meeting within 5 business days. So it's a very quick turnaround. So you need to really get your attorney involved to evaluate it and see, is this something we have to do? And if not, what are our legal defenses for not doing it? And it's again, quick turnaround for that. All right, so some proxy rules for condos. You can use limited proxies at annual meetings. Typically, it's a limited proxy for condos. Most anything that requires a vote should be done by limited proxy. It's typically provided for in the statute. A limited proxy says, I can't be here and so is my proxy, but on this issue, I direct them to vote yes or no, or whatever the case may be. So a limited proxy does not allow the proxy holder to say, hey, I've got 10 proxies here and I'm going to vote however I want for them. If it's something that requires a limited proxy, they're just there to essentially say, I'm here for them and here's how they voted on this issue. A general proxy does allow the proxy to use their best judgment, but really there's not many instances in a condo situation that allows them to exercise their discretion on anything that's substantive. It may be for moving to adjourn a meeting to a later date. That could be from the general powers that you don't need a limited proxy for. But by and large, everything for condos requires a limited proxy. Voting by proxy is not permitted for a board member election unless the association has 10 or fewer units. So if it's a really small association, that would be one of the only ways. Limited and general proxies may be used to establish a quorum. A proxy is valid for 90 days, but this is helpful if you are trying to vote on something that maybe has a high threshold of 2/3 or 3/4 of the members, and you're getting close and you've got a ton of proxies, but not quite enough. You can move to adjourn the meeting to a later date within that 90 days from the date of the original meeting, and you're not having to get new proxies. Those proxies will effectively roll over, and you can just go out and try to get additional proxies to try to effectuate a vote that you're looking for. So that's why it's good to have the proxies in place and encourage owners so that if you can't make your quorum, or if you're close but not quite there for having a vote, that then you can use that proxy. Otherwise, if you show up in person and cast a vote without executing a proxy, and then that meeting's adjourned, you'd have to show up again later because you can't recount something in person. It'd have to be by proxy vote, for example. So for HOAs, directors may not vote by proxy at board meetings. That's actually the same rule for condos too. The members have the right to vote by proxy. It doesn't have the same limitations like condos do in terms of the limited proxy requirements. There really are no limited proxy rules for HOAs like there are for condos. Now your documents may require it, but there's nothing in the statute that may require it. And again, proxy is valid for the meeting for which it's intended, and it expires 90 days after the date of the meeting. But you can, again, use that for the purposes of, extending the meeting for quorum purposes, and trying to effectuate that quorum. You can adjourn it to try to get more proxies. You may also be able to use proxies for the election of directors. Depends on what your documents require. So that's another big thing. That's a big difference between condos versus HOAs. All right, so that's what we have on elections. I'm going to take a look and see if we have any election-specific questions. I'm going to scroll down here just to see. Let's see. Let's see, Jack, Ashley, I'm going to answer this one because it involves, election of director, but really for directors. Jack says, why do directors need D&O when they're personally immune by Florida Statute 678? You still want to have the D&O policy in place because you want to have the insurance come in and kick in and pay for your defense rather than the association using its own funds to pay for legal defense. You might be right, and you may be immune, and there may be indemnification that the association may have pursuant to anything in the governing documents or the applicable statute, but that still doesn't provide you with the insurance and the defense in the meantime to fight the lawsuit. And so that's where, and those lawsuits can get expensive. So that's why even by itself, or if you did, maybe there's a gap in the immunity there, for example, if you acted outside of it, they may not be covered by that statute that you mentioned. That's why it's so important to still have directors and officers liability policy. One question was, is the 8-year term limit on condo, was that not retroactive? There's some debate amongst this. There's been some differing positions, and I would need to look at the arbitration decisions on it to see, because arbitrators are kind of notorious for maybe taking different positions on it. If you think that you're running up against that issue, I would just get an opinion from your attorney on it of how best to handle it. At one point it said it was not retroactive, and then it applied from 18 going forward, but then there was some maybe discussion that it was retroactive. So I'm not giving you the best answer there. It just really would determine on what the most recent arbitration decisions are saying on that. If you do have a director on a condo that served 8 consecutive years and they're trying to run again, I think it would be good to get an opinion from an attorney so that, whether it's me or another attorney that can advise you on what the proper steps are. And then you can make a decision as a board from there as to if you're going to treat it as applicable or not. Mary Rose says, our proxy forms have owner names and signatures, but also includes the meeting issue vote tally, i.e. to waive audit. Is this a breach of confidentiality of how the owner voted? No, the only thing really that's required by secret ballot is for the election. And that's for condos only. A lot of times when you have your proxy form, if you include that as to what the voting issue is going to be, you need to have that just to show what the voting tally was. So unless your documents specifically require that whenever you take a vote on an issue that it has to be done by secret ballot, it's perfectly acceptable to have the voting preference on the proxy itself. You're allowed to see what other members vote for, in other words. Mary Rose, you had a question about 80-20 rule for occupancy of 55 and older condos. It's kind of beyond the scope for what we have for the board member certification. And what I can tell you, though, from what I understand from it, is just that in order to be designated, typically you cannot what's called discrimination by age unless you go through the appropriate process and you have to be approved. And one of the things is in terms of occupancy of the number of occupants that are 55 and older. In order to keep that designation, and you have to be consistently enforcing that in your governing documents. But beyond that, if you have a question of whether or not your community is abiding by that, I'd have to take a look at your community and kind of how it was set up before I can answer any further questions on that. All right, so going into financial issues. So we're going to talk about budgets, your operations, your reserves, and your accounting method. You want to monitor your accounting records, must be open for inspection. Accuracy, of course, is critical. Establishing assessments, your regular assessments, that's coming from your budget adoption and how you're going to fund your budget each year. You can also pass special assessment for unanticipated expenses that come up. And then what your financial reporting requirements are, we'll talk about that. So your budget allows the association to prepare for the upcoming year. The proposed budget includes the daily operational expenses and your estimated revenues. Again, as I talked about before, your budget is an estimate. It's not a bright line. We can only spend this much amount, and if we reach that amount, we have to stop and wait for the next year. You may do that if it's something that's a non-emergency issue that can wait, but if things need to be done, example I like to give, if there's an issue with a sidewalk that's a potential liability concern and that needs to be smoothed out and you didn't realize it and you've already exceeded your kind of general, common area maintenance budget for the year, spend the money to smooth it out so that you don't want to have somebody else trip over it and cause an injury and now the association is going to be sued, right? So as long as you have the money in your operating budget to do it, the budget again is just an estimate. For condos, the owners are entitled to 14 days written notice of the budget meeting unless the bylaws or the governing documents provide for longer notice. The meeting notice is to be accompanied by a copy of the proposed budget. For HOAs, the association just has to provide a copy of the budget or that a written notice that a copy is available upon request once it's adopted. You're not required to mail it out in advance, though. That's the difference between the condo and the HOA side. Some HOAs choose to do that anyways, but it's not a requirement like it is for condos. So again, your budget, though, is going to be a zero base. And what that means is that you're going to look and you're going to say, what are our expenses first? If it's $500,000, then you're going to have to look for $500,000 of income. You don't want to have $500,000 of expenses and $1 million of income, right? That's not a zero-based budget. Your annual budget, it's going to be the governing documents are going to set forth the responsibilities for preparing, implementing, and funding the budget. Most of your budgets are going to contain your administrative costs, your maintenance, taxes, insurance, reserves. Your largest line items may be your taxes, your utilities, and insurance. Your landscaping fees, especially. Those are your biggest, your management fee. Those are going to be your biggest line items in your budget typically. The accounting method, whether or not it's a cash basis or an accrual basis, cash basis is income is recorded when it's received. Expenses are recorded when they're paid. An accrual basis is income is recorded when they're earned. Expenses are recorded when they're incurred. Which one's better? Accrual gives a better overall financial picture. GAAP requires an accrual basis. So a cash basis is kind of similar to your checkbook. An accrual basis is when it's earned and when expenses are incurred. It's more useful for comparing the results of the budget to the actual activity. And it takes into account some of the timing differences too. So it gives you a better snapshot of where you're at. Your financial reports, I think this is important to kind of look at. Your financial reports, it's the total annual revenues of less than $150,000 for your community. You just have to provide a report of cash receipts and expenditures. If your annual revenue is between $150,000 to $300,000, it's a compiled statement. If it's $300,000 to $500,000, it's a reviewed statement. And then if it's $500,000 or more, you have to conduct an audit. So a compiled statement, there's no audit or review, there's no opinion expressed. CPA must have client and industry knowledge. And then you're looking for any obvious departures from GAAP. A reviewed financial report, it expresses a limited opinion that the statements are in conformity with GAAP. Generally look at the related party transactions, segregation of duties, cash and other key financial items. And then you look at significant fluctuations, indicate that there weren't any material issues. And obviously an audit, that expresses an opinion that the financial statements present fairly the financial position and are prepared in accordance with GAAP. And then you look at internal controls and perform analytical tests. So now if you're an association that has a higher reporting requirement, you can vote to waive or reduce the reporting requirement, but it has to be done each year that you want to do it. And it requires majority approval of the membership at a meeting where a quorum is met. It's usually done by communities that don't want to pay for an audit each year. They might waive that and have it done every couple of years, but you do have to have an actual vote of the membership to do that. This thing on the bottom here, there's a penalty where an owner is entitled to a copy of the financial report. And if it's not provided and the owner gets the DBPR involved and you still don't provide it, then you're penalized in that you cannot waive your financial reporting requirements for the fiscal year in which the request was made and for the following fiscal year. So there's a penalty in that if you're not being forthright with it and you're trying to waive your financial reporting requirements, you're not allowed to do so. That's just in the Condo Act. All right, so funding the budget. Assessments are required from each owner. The unit or the parcel serves as security. Other sources of revenue may come from rent, interest, or any other type of income, but by and large, it's going to come from your assessments. One thing I ask, please don't budget for fines. I think that sets up your community in a way that you're going to be looking for fines. It's kind of like some of those notorious areas in Florida that were for speed traps, where you hear that they had quotas for speeding tickets each month. Don't do that for your community and establish a fine as a way to try to keep your assessments lower. I think it just established a bad precedent for finding things that might not exist or being too aggressive with your covenant enforcement. For condos, this is one thing where sometimes you'll hear or somebody says, well, I thought we can't, we need to raise our dues. The previous board, was trying to keep the dues too low and we really have more expenses than what's been reported. And they'll say, well, but we can't raise our dues more than 15%. You are allowed to. The only thing in the statute that says if you raise your dues more than 15%, that the members have the ability to propose an alternative budget and it can be voted on and needs to be approved by a majority of the members. That's the only thing. For 8, you can have a limitation in your governing documents that prohibits it, but in terms of a Florida statutory procedure, there's nothing in the HOA Act, and for condos, it's just that the members can propose an alternative budget. Then you talk about the collection of assessments. The manner for collection is stated in the governing documents or the bylaws. For condos, assessments have to be paid no less frequently than quarterly. And then you can accelerate assessments for any type of delinquency. You have to give appropriate notice for it. You want to manage your delinquencies. So this is for condos and for HOAs. I talked about establishing a collection policy. You want to have enforcement procedures applied fairly and equitably to all owners. You want to use the statutory remedies. You can have amenity restrictions. So if an owner is 90 days delinquent, you can actually suspend their use rights for the common areas until the delinquency is paid. Now, obviously being able to do that is, it's one thing to actually vote on it. The other thing is practically suspending it. It's better, obviously, to do it if you have like a key fob or access that you can shut off. You can suspend their voting rights. We talked about that. You could take application of rent. I teach a 1-hour class just on collection strategy, so I'm not going to spend all that time right now. But the biggest thing I think is having a collection policy in place, understanding that, you're not trying to take people's property, but the biggest tool that you have is the claim of lien that can be recorded. The claim of lien is the instrument that's recorded in the public records that places notice of our interest in unpaid assessments and that you then use to foreclose on it. You can foreclose on a claim of lien in the same manner as a bank forecloses on a mortgage. And that means you can take somebody's property. The only really type of instruments that have a higher priority than a claim of lien, by and large, are the first mortgage or any type of tax lien that was recorded prior to the condo or the HOA claim of lien. There's some variances around there, but that's generally the rule for communities. And so that's a pretty high priority document. In other words, you could have a claim of lien that was recorded years after a second mortgage on the property, but you would have a higher priority to that. So it's really important to have that collection policy in place so that you're acting timely. What we don't know yet is with everything obviously with COVID and some of the financial difficulties, the unemployment numbers, if we're going to see that. And I don't think it's translated too much, maybe even as much as what we thought. But if people stop paying their assessments and you have a rise of delinquencies, you want to act on those fairly quickly. You're not trying to kick people out, but at the same time, your best way to make sure that you're paid is to act sooner rather than later, because otherwise those balances get out of control. You have late fees and interest. Then you have potentially your now banks possibly foreclosing, and it takes them longer than associations to. But now you have the issue of now you're competing with the bank for who's going to get paid first and take over the property. It's better to have a collection policy in place. And I won't spend more time on it to say that, again, talk with your manager to make sure, hey, do we have a good communication on this? And do we need to get our attorney involved to help with a collection strategy and policy for us that works for our community? That's the biggest thing I can recommend for you. One of the biggest takeaways that I have for you coming out of this today. Real quickly about renters, from a delinquency standpoint, you can send a renter a tenant demand letter. They're required to pay the rent until further notice. One of the unique things is that you're not actually allowed to tell the renter what the delinquency is because you'd be disclosing the debt to a third party. What we just say is that you need to pay the rent until further notice and that we're not allowed to provide you the delinquency amount. You're encouraged to, of course, contact your landlord if you'd like to have this end so that you don't feel like there's this weird, you need to, am I allowed to send this to the association? Am I going to get in trouble with my landlord? We're always very nice to the renter. We like to make them feel, of course, comfortable with paying the rent because we want to make sure that then the association is paid. A renter is protected from an action by the landlord that if they pay a rent demand that's appropriately provided by the association, the landlord is not then allowed to evict them for non-payment of the rent. So that's a good thing, and we let the renters know that. You can evict if they don't pay it. I'm usually not a big fan of that because all eviction does is get the unit where it's vacant again. If they're not paying and there's a delinquency, you're better off just foreclosing, and that's a way to take control, and it effectively evicts them anyways. So, but there is some teeth to it just to let the tenant know there are ramifications from them if they don't pay the rent. One other thing is that if there's an abandoned unit from a condo standpoint, you are able to go in, make repairs, and then charge it to their account. You can also, instead of just foreclosing, if you can show that it's abandoned, you can petition and get a receiver appointed right away to then have the receiver rent the unit out and then offset the rent with the delinquency, and the receiver takes their fee. But you can do that and try to get a quicker way to take control of a unit by getting a quick petition signed from a judge rather than going through the whole process of foreclosing and everything. So that's a right that the condos have that was put in response to the housing crisis that we had, in the late 2000, the 2009, 10, 11, 12 or whatever. And that we have that tool in place now for condos. All right, surplus funds. It includes all the excess monies retained by the association after deducting expenses. If it's a not-profit corporation and surplus is not from a special assessment, the funds cannot be returned to owners. What you're basically doing is you can be credited towards their next year's budget or allocated to the reserve account is what we typically recommend. A surplus, a special assessment, it can be refunded to the owners. What usually associations do, though, is they will find a way to put it into their reserves or for their next year's operating budget, because it can be tricky as to what if the special assessment was levied a year ago and then the properties have changed hands. Do I need to send it back to the previous owner or to the current one? Or is this a good way for us to further bolster our reserves rather than, the owner's going to have to pay for it anyways. If we've got the funds available, let's just bolster our reserves right now. So that's what a lot of associations will do there. So an overview of reserves, the purpose is for major repairs or replacements. If they're used for other purposes, you need to define that. You need to be careful from a funding standpoint. I know some associations like to try to establish like a rainy day reserve fund. The difficulty with that is that reserves typically are funded pursuant to a schedule that's tied to an actual physical element, that has then a useful life, a remaining useful life, a cost of repair. When you have a rainy day reserve fund, it can be subject to like, what are we actually using this for? And is it properly being set up or not? The funds must be separate from other operating funds. The required reserves are the roof reserve, the pavement, painting, and any other item for which the deferred maintenance expense or replacement cost exceeds $10,000. So these are the statutory condo reserves that you have to have. Budget must contain a fully funded reserve schedule. So what that means is that when you do have reserves, you have to fully fund them. Fully funding them means that if you know that in 10 years from now, you're going to need X number of dollars to replace your roofs, then you're going to have a funding schedule for each year to make sure that you have that money when you need it. If you are trying to save on your assessments by lowering the reserves, the only way you can do that is to have a vote of the membership to waive or reduce the reserve amounts. So have to have a fully funded reserve schedule unless there's a membership vote to waive or reduce them. Then you have pooling method versus a straight line method. Pooling is a pool. It's basically the reserves are in a pool of money that's available for the cost of any item specified in the reserve pool. And so what that means is you still have to keep track of the reserve items, but as long as you're pulling from what I'm like, let's say you have to replace the roof and it's going to cost more. You have to do it a year or two sooner. And so you don't have as much money allocated to that reserve item. as long as it still is part of a pool, you can take that money from that pooled reserve and fund it without having to get a vote of the membership or specially assess them. If they were straight line funded, if you had, let's say, $500,000 in your roof reserve at the time that you need to do the work, but it costs $700,000, that $200,000 difference would be made up of by either getting a vote of the membership to take from another reserve account, or you'd have to pass a special assessment. Even if you had other reserve balances for future expenditures, you couldn't dip into those if you didn't have a pooled reserve. So that's why it's important you have a pooled reserve account. And a lot of associations have gone to that. For HOAs, the budget may include reserve accounts. If reserve accounts are established, it's determined by a formula, maintained and funded, like we just kind of talked about. It can be waived upon majority vote. There are basically three ways that you can have reserves for HOAs. If the developer has established them and funded them, you have to continue funding them as an HOA. If you have authority in the governing documents to establish them, why the board has done them, for example, or the members can vote to establish the reserves. Those are the three ways that you can have reserves for HOAs. Reserve accounts can be terminated by a majority vote if they, and again, you have to then fund the reserves pursuant to the appropriate formula. I talked about funding methods, straight line versus pooled. We already talked about that. Florida law provides that reserve funding should be included at the fully funded level. Owners may vote to waive or reduce the funding level, but the budget must contain the fully funded amount. Board does not need to present a less than fully funded option to the membership. So it's not like you have to do that. It's just that if you do choose to have a less than fully funded option, that the members have to vote on it. So what typically will happen is the board will maybe have two different budgets, one with fully funded reserves and then one with less than fully funded. And you can make a motion to adopt the fully funded budget if let me put it this way. You would vote to establish the budget for the less than fully funded reserves, provided, however, that if the vote of the membership is not obtained, then the fully funded budget has been adopted. That way you don't have to then go back and have another board vote to establish the fully funded budget. So that's one way to do it, so that if the vote doesn't work, then you've already got a budget in place and it's for the fully funded amount. So the reserve schedule, it's all the required deferred maintenance and capital expenditure items. You have to have an estimate of the useful life, the estimate of the remaining useful life, the estimate of the costs, estimate of the fund balance at the beginning of every year, and then the required funding for each budget year. So the best way to figure out what your reserve schedule will be is to have a reserve study done. Florida law does not have a specific law about reserve studies, but part of the fiduciary responsibilities of the board, you may want to do that. I have every 3 to 5 years. It could be every 2 to 4 years for your community. A reserve study is done by a reserve analyst. It's a professional. That's what they do for a living. They basically come out, take a look at the components that you're reserving for. They'll look at what the remaining useful life is, what the funding is. They'll understand maybe different funding requirements, maybe cost of construction, certain things that will affect the funding level of what it's going to cost. And then they'll help then establish your reserve schedule for you. So that's why it's important to have it. You may want to provide an update without the site inspection annually as part of your annual budget review process. So maybe, you have the more substantive reserve study done every 2 to 4 years, but in the off years, you maybe just say, hey, without coming out here, is there anything you can take a look at and charge us a more nominal fee? Is there anything we need to tweak from a funding level? Something like that. That might be a good way to do it. The biggest reason why you want to have those reserve studies done is that you're being efficient and not either over or underfunding, depending on potential changes in your useful life or what the repair cost is going to be, due to whatever, change in the industry. That's why it's so important to have that, so you're staying efficient with your funding level. All right, so that's what we have on the financial side. I'm going to look back and see if I had any questions here. William said fully funded based on a schedule, correct? Yes, that would be how you could determine how your reserves are being fully funded. All right. I'm going to go into official records. So some records maintenance. The official records of the association are open to inspection by any association member or authorized representative at all reasonable times. The right to inspect includes the right to make copies at a reasonable expense. The official records of the associations are maintained within the state The record shall be made available to owners within 10 working days of receiving a written request sent to the board or the designee. The association is not responsible for the use or misuse of the information provided to a member or a member's representative. So that's one thing too, is like when you're providing a copy of these official records, sometimes boards will say, well, I don't trust that this owner is going to use this in a nice way. They're going to try to embarrass their neighbor or something like that. We have to provide those, and we are shielded from any potential liability from an owner coming after saying, you know, you let this owner take a look at this record. They took a look at my, you know, my ledger that I wasn't paying my dues, and now they're harassing me about it. Well, we're not liable to you. We have to make that record available to the person requesting it because it's an official record that has to be made available. Some of the records that have to be maintained from a permanent standpoint for condos, they have to maintain the plans, permits, warranties, and other items provided by the developer, the governing documents, the minute book, and the accounting records. And then for HOAs, this is for 7 years, although I could see this going to permanently maintained. Associations must maintain for at least 7 years the current roster and the mailing addresses, voting certifications, current insurance policies, copy of the management agreement, lease, and any other contracts, the bills of sale or transfer of all property owned by the association. And then this is the catch-all, all other written records related to operation of the association. That can be all kinds of host of things. I think I have one of our board members on here. I know that there was a request of somebody that requested a guest log that was maintained by their front guard, that they wanted a copy of that. And I'm not sure if that was in this case, but it's happened in another case where I have had the discussion like, well, do we really have to provide it? Well, have you asked the security or the access control personnel, is that a requirement that they maintain that log? Well, yes. Okay, well then that's a written record related to operation because it's part of an access control measure. So from that standpoint, if you're maintaining it, you have to make it available. It's a pretty big catch-all provision that you have under the records maintenance provision there. So for condos, some unique, different, some differences there. You have to maintain the ballots, the sign-in sheets, and the voting proxies for 1 year from the date of the election. All rental records. Copy of the question and answer sheet is provided for in the statute. Copy, there's an inspection report that has to be done. You have to do an inspection report to make sure that you're properly insured. And then as of July of 18, you have to keep your electronic voting records. That's not in the case for HOAs, but I'd still recommend keeping those because that could be deemed to be at some point an official record that whether it's written or not in written form, they may interpret that to be as a document that has to be maintained. So condominiums have website and posting requirements. As of January 1st of 2019, condo associations of 150 units or more have to have a website. So probably if you're on here and if you're in a community of that size, you already have this in place. I'm not going to go over this. And if you'd like to have a copy of the presentation, it'll list this out for you. But these are all the documents that you have to maintain on the website. I would say that there's a push to either lower the total number of units, so maybe you go to 100 units or 50 units, and they might even include HOAs. There's going to be a push for HOAs and condos to have websites as a method of making it easier for members to have access to information. And it's just as everybody becomes obviously more and more, using their computers for everything in their lives, that it makes sense to have associations have websites. Be mindful of what you're including though from your website for what's open to the public versus what members should then have a login and access to. There was, it was either last year or the year before, there's kind of a small cottage industry that popped up of people claiming to be testers of association websites and saying that it wasn't FHA or ADA compliant, and then saying, well, we would like for this website to be fixed. And by the way, we also have this amount in damages because we've incurred legal fees for testing your website. They've kind of gone away a little bit, but the less you have that's available for a public entity that can poke around on your website, the better off you are. You might just have a landing page that's FHA and ADA requirement, and then make any actual records that you want, all the other pages behind the login wall, so that then only owners have access to it, and then owners would have the ability to still make claims. But and this is not an FHA ADA website presentation here, but it is something that's come up. So just something to be mindful of with your websites, maybe something to ask of your management company, and if you're compliant, or if there are better ways for you to handle stuff. So records that aren't accessible, records that are protected by attorney-client privilege, those generally are not accessible, although there's some debate as to whether or not if it's not for a proposed or pending litigation, as to whether or not that now has to be made available. If board members are taking an opinion written by their attorney and kind of reading from it at a board meeting or referencing it, there's an arbitration decision that has found that maybe you have waived it by reading it out. So just be careful about doing that. Maybe you just say, hey, we can't do this. We've received an opinion from our attorney and we can't go further than that. That's one way to protect it. I always try to protect, of course, the interests of the association and not making those attorney-client privilege communications available. But there may be instances where you have to if it's not for proposed or pending litigation, but keep those separate. Any information obtained in connection with the sale or other transfer of a unit, that would also not be accessible to owners. Any personnel records that you have, and again, personnel records can be arguable as to what that includes. I typically think if it's like a disciplinary report or payroll information or anything HR or medical related, that would kept separate. Medical records, this comes up more, especially in condos when you're having FHA and ADA requests, and of course for HOAs too, but if you're getting those and it's based upon some type of a disability, perhaps the owner might be sending letters from their doctor stating that I need this accommodation because of this medical condition, this disability that I have. That's a medical record that you should keep separate. So all this on this slide is kind of like, I like to say, here's the one pile that's open to the members and it's a lot larger pile. Here's the other pile that everything needs to be kept separate. So make sure that you're keeping that. Electronic security passwords, software and operating system access information, of course, that's all kept separate as well. Other records that aren't accessible, social security numbers, driver's license numbers, credit card numbers, email addresses, telephone numbers, emergency contact information, other than those provided by the owner for notice purposes. Owners can consent in writing to allow the disclosure of their protected contact information. Some contact information which requires no written consent for disclosure includes the name, the unit or the property address, the mailing address, and any email or fax number that's been provided to fulfill notice requirements. So as long as the owner has consented to provide it, it doesn't require written consent for disclosure because they've already consented to provide that to you. For statutes, it was clarified that all telephone numbers may be included in a directory if the owner has included their telephone number, although an owner may choose to not have their numbers listed, they may opt out. And then you can consent to the disclosure of additional information like your email address. So the biggest thing is that if you have an email address from somebody, you cannot use that as a means for communication unless they specifically state, I consent to receive it. Like they have to opt in, not if you just happen to find somebody's email address, you can't say, well, we have it now. That's how we're going to communicate with you. And we're going to make your email address open for inspection by members. Owners have to specifically opt into that, both for receiving notice and for their email address to be made available to the membership. So that's a big thing with emails and contact information. All right, so inspection, we talked about how all these official records are to be made available. There's some teeth to it that if you do not make them available within 10 business days, that an owner could have a statutory claim for damages of $50 per day for each day that they were not made available. So it is important to comply with that. Now, there's a difference between inspection of records and an owner mailing you asking for copies of documents. Just for asking for copies is not deemed to be an official record inspection request because you're not required to go through and find every record that they're asking for. All you're required to do is just make the official records available and then they can find it. If you choose to do that as a way to kind of maybe limit the time for the inspection and kind of get them in and out of there quicker, that's okay. But in terms of an owner saying, I demand copies of the budget meeting from October of 2017 and this, and this, you're not required to do that. So that's not considered necessarily a valid request. One way you could reply is to say, hey, we're not going to do that, but if you'd like to make an appointment, please send us a formal written request for an inspection of the records, in which case then we will contact you and make them available within 10 business days. Or you may not even require them to go through that. You can just say, we're not going to make those copies, but we'll treat this as an inspection request and you can come next Friday to come inspect them or something like that. So just have a policy in place, make sure you're handling those appropriately. All right, so additional legal updates. What I'm going to go through are some laws that changed from previous years. I know I did see a question about one of the bills that is kind of the big condo HOA bill.
And John, I know you had asked that. I'm going to get back to you. I'll shoot you an email. And the reason why I'm not going to go too far into it is just because it's going through committee right now and there are still changes being made. So what we'll do as a firm for any legislation, I think there's going to be some good legislation that's going to be passed this year, more so than in previous, the last 2 or 3 years, is we will be providing a legal update to let you know if there's anything that we see that we think that you as an association, that we would recommend lobbying against. We will make sure and we'll send out an email blast to the people that receive notification for this board certification event today. But for the legal updates, I don't have a lot as to what's going to be coming up yet, just because it's too soon and things are being taken in and out and we're not sure what's going to pass yet. So, but John, I know, John, you had asked me specifically, and I work with you, of course, a lot. So I'll make sure to reach out to you more individually on that. But just for the purposes of getting us done today, I'll talk about some more recent changes that took place. So emotional support animals, there was a change to Florida's Fair Housing Act, heavily borrows from the federal Fair Housing Act. It states that it's unlawful to discriminate in the provision of housing to a person with a disability or disability-related need for, or who has at any time obtains an emotional support animal. An emotional support animal is defined as an animal that does not require training to do work, which alleviates one or more identified symptoms or affects a person's disability. So they've kind of added in and borrowed some from the Federal Fair Housing Act. There are some protections, though, for entities like associations that are receiving these requests. One of them is that documentation may not be prepared by a healthcare practitioner whose exclusive service is to prepare documentation in exchange for a fee. You can Google these places. There's one out in California where she says, for $99.99, I'll get you your emotional support animal form, and we'll do a quick 5-minute video consult. That way I can say that I treated you, and then I'll get you this form. Like, that's clearly somebody that's doing it that's their exclusive service, is prepare the documentation. The other thing in that instance is that even if it's not their exclusive service, it says the requirement is that the healthcare practitioner is out of state. They must have provided in-person care or services on at least one occasion. So again, if they're finding somebody out in a different state and the person's here in Florida and they've never actually treated with that person in state, in the same state, then, that's not going to be acceptable. And the landlord, that's what the use is in the statute, but I would think that the association could be lumped into that definition, may also require proof of compliance with state and local licensing and vaccination requirements for the animal. And there are some criminal penalties. It's a second-degree misdemeanor if there's any false or fraudulent proof of need for an emotional support animal. So there is some teeth that we can ask some questions. We can limit the attempt by some of these people profiting off of it, where they're clearly just, you're paying for a letter to help get you an emotional support animal where you might not actually qualify for it if you went to a more appropriate healthcare provider. So that's what is in place for, and this will be applicable for community associates, especially more, I would say, condos. This request come up more, or in maybe townhome associations that have pet restrictions or something like that. You'll see a lot more of these emotional support animal issues coming up. So communities with pet restrictions are strongly encouraged to adopt procedures for requesting accommodation in the form of an emotional support animal. And the reminder is that a pet and a proper emotional support animal are not the same thing. That's one thing I had, 6-7 years ago, where a board said they were a no pet condo. And they said, well, Ed, this is pretty easy. We don't have to accept it because we don't allow pets. So, well, an emotional support animal is not the same thing as a pet. Think of an emotional support animal, if it's proper and they're entitled to have one, as the same way of somebody saying, hey, I need a ramp to my unit because I'm disabled and I need to have a ramp for my, where my assisted device is. That's the same thing. You have to think of an emotional support animal. It's a thing that they need to help them enjoy their unit in the same way as somebody that doesn't have the disability. That's the way to think about these things. Some additional updates: law enforcement vehicles, including provisions which precluded an HOA or a condo from prohibiting a law enforcement officer from parking their assigned vehicle in certain areas. I think common sense would dictate that if you have law enforcement, even if they live in your community, you don't want to get on their bad side necessarily if they're parking on the street. You might want to allow it. A lot of those communities probably find those where they're willing to do drive-arounds and kind of at least have a presence in there or report back anything that might be out of whack. So just be very careful of, if you're even thinking about sending a violation letter to a law enforcement officer, that lives in your community for parking, just double check that before you do it because of this statutory change. Another one is fireworks. It allows fireworks on designated holidays. It includes New Year's Day, Independence Day, and New Year's Eve. It doesn't supersede any prohibition against the use of fireworks in the governing documents for any other days that you may have. Some additional condominium updates. We had some questions on this. There was one about electric vehicle charging stations. Basically, the reason why the statute is in place is that putting an electric vehicle charging station would be considered a material alteration that would normally require usually 3/4 membership approval unless you have a different threshold in your governing documents. But because we're trying, of course, more and more people are getting electric vehicles that need charging stations, and especially in condos where you have common element parking, they wanted to make it so that you can install those without necessarily having to have membership approval. But you have to go through these hoops. I'm not going to go through all of them, but it's basically to make sure that the owner is properly having plans in place for installing it, that they're paying for any additional costs, and they're protecting the association. That's the best way to summarize it. So that's kind of one of the condominium updates on electric vehicle charging stations. From a couple years ago, there was an update for amendment to the governing documents. If you are amending them, you have to contain the full text and then show strike through of what you're taking out and underline what you're adding in. We've already done that, but it's now in place. It's been in place for condos, but now you have to do that for HOAs. This is one big thing. The second bullet point, it says that under 72306, any notice provided there, so that's for any type of membership meeting, that it has to be mailed or delivered to the parcel owner's mailing address on the property appraiser's website in addition to their property address. So now this has created an obligation on the part of the association to double check the property appraiser to see if there's a different mailing address there than what you have on file. And so this is important because if you don't do that and you have a vote and somebody wants to challenge it, they can say, all right, show me that you mailed it out to all the people on their parcel. It's probably going to be an owner that didn't receive notice of it, so they could vote no. And they can say that the vote is invalid because you didn't give appropriate notice for the meeting because you didn't mail it to the people on their property appraiser mailing addresses. So talk with your management company. This has been in place for a couple of years, and I've talked about this before, but it's really important to make sure that you're doing that because it creates an obligation now on the part of the association to double check the property appraiser records. And that can be a big deal. I know some of you on here are part of large community associations, 1,000+ member master associations. That's a big undertaking to make sure that you're up to date on the property appraiser website. The last point here is on assessment payments. They kind of close a loophole where if an owner was delinquent and they tried mailing in a check for less than the amount that they owed, and they put on some type of a restrictive endorsement like payment in full, that would not allow them to then consider the account to be paid in full. It says that regardless of whatever you put on there, if it's less than the full payment, then it's applied as a partial payment. So it's a way to kind of close a loophole that was in place before. All right, then one of the last substantive slides that I have here is the Marketable Record Title Act. This is just a reminder if you're in a homeowner association that is coming up on 30 years, that you need to know about the Marketable Record Title Act because your covenants could expire if you are not preserving them with it before the 30-year expiration. The 30 years runs from, it's a little bit more nuanced, but if you look at 30 years from the date of the recording of your covenants initially, that's the safest way to make sure you stay within it. The more technical answer is that it's really 30 years from the initial for each parcel when it became subject to the covenants. But if you look at 30 years from the original recording, that's the thing. The good thing is that it's very easy to make sure that you can preserve your covenants. It's done by board vote, or now there's a change that allows even an amendment to serve as a preservation. Talk with your legal counsel about that. But what you don't want to have happen is have the 30 years go by and now you have to do what's called revitalization of your documents, because that requires membership approval and it requires approval from the state, and it's a lot more expensive. So take a look at that. The main thing here is just know that there are alternative procedures for martyr preservation. It also allows non-residential HOAs, so that's what they call property owners association. So a non-residential association can also have their covenants preserved. So if any of you are in a non-residential commercial parcel association, you can have your covenants preserved. And this is a way to kind of open it up more beyond just the residential HOAs. Oh, the other thing too is that it requires the association to annually consider preservation. And this is a instance of bad drafting by the legislature, because it doesn't say, for communities such and such, where maybe if you have 10 years or less until your documents are to expire. I can see that. and why you have to consider it annually, because you're coming up on the time period. But what if you're a brand new association that your covenants don't expire for 30 years? Do we still have to say every year, hey, we consider it and we don't need to do anything because we've got 25 years left? I guess that's what you're required to do. Just consider having something as almost like a placeholder each year where you bring it up and show that it was in the minutes that you discussed it. So that's another thing that's required. All right, so in summary, you are board members. You have the fiduciary obligation to set aside personal agendas and put the association first. You want to stay focused on the job at hand. Be familiar with your governing documents. You don't have them memorized, but be familiar, of course, and operate pursuant to them. Know your duties and perform them competently. You want to set goals and establish values, and then obtain the necessary education. I think for all of you, we had over 100 people here today, that making the commitment to come and listen to me on a Friday morning is a commitment to you for obtaining education rather than just signing off on some certificate. So I really appreciate you attending this today. And I know we have some questions here. I'll be happy to have those. I kind of had estimated that it's about 2.5 hours. So I'll try to answer questions for a little bit more. And if I can't answer them because it's more specific for your community, please feel free to reach out. We'd be happy to represent your community on it, but I'll try to answer the questions that we have. And I have our contact information here, both for me and then for Nanny, if you'd like to email her for a copy of the certificate and for a copy of the PowerPoint slide. If you'd like to have a copy of the actual video presentation, we're going to be working on that and providing a link where it's available in the cloud. Email us back and we'll make, maybe in a couple days, early next week, if you can reach out to us on that, we'll make sure to make that available for you. So let's see what kind of questions we have here. So Larry had said, just when we talked about law and ordinance, we're talking about insurance. Law and ordinance is an additional amount over the policy limits to cover code changes. Example, window replacement or hurricane code. Yep, exactly. Thanks, Larry. Mary Rose says, can you comment on pros and cons of unwarrantable amenities on condo properties, clubhouse, pool house, or pool that are not owned by the condo but are leased? Mortgages do not always approve these situations. That's a pretty specific instance. I think that's just part of the, if you've got a lease provision there, what protections do you have in place? Are you going to be charged? If I understand it correctly, if you're leasing out those amenities from somebody else, that the association has the right to use those, that you can't, warrant those. There's just going to be, anytime there's like a lease restriction like that, you need to see what can come back on us as an association if we are leasing those out, or if we have engaged in some type of a amenity, a membership or something like that, that could we be hit as an association that can be passed on to our members if something takes place? What insurance do they have? So if I'm understanding that, Mary Rose, I hope that I answered your question. Otherwise, that would be more of a specific question, because that's a more unique situation that you have there. How can you do a strategic planning session without an open forum? No, that's a good question. I think that should be done in front of the membership. I think that could just be done in a meeting where the board discusses it. Maybe some members have some ideas, but that should be done in an open meeting if you have a quorum present. So yes, that's a good question, William, when I talked about a strategic planning session, but that should be done in front of the membership where it's noticed. Mike wants to know, can a condo association mandate and enforce owners who rent to charge renters an amenity fee? That is only if it's in your governing documents. And even then, condos are pretty limited as if that fee goes back to the association. You can charge a security deposit as a condo association, and you can charge a transfer fee, but the transfer fee can only be charged if you have approval powers over the lease or the sale of the unit. Aside from that, like a renter amenity fee that's being paid to the association, I don't know if unless it's one of those couple charges, whether or not you can enforce that to be paid to the association or not. Mike wants to know, can a condo association require and enforce owners to obtain building permits for construction of their units? I think certainly if it's part of that, and if it certainly could potentially impact the common elements, if it's something that requires approval of the board for the work that they're doing, I think that it's certainly appropriate to require proof of building permits that have been obtained. Can a condo association require and enforce owners who rent to have proper business licenses? That would be, you would need to have that as a condition, maybe of like a short-term rental. If you're going to allow it, that should be in your declaration if you're going to use that as a potential for finding. Aside from that, can you adopt it as a rule? Potentially. One thing is, if you suspect that they don't have it, you can always make a complaint to not code enforcement, but well, it could be code enforcement. I'm trying to think of the appropriate municipality that governs that from the local government side, that you could still file that as a complaint because they are complaint driven. But in terms of making that a requirement, if there is a business license that is required for what they're doing, I would want to make sure I would prefer to have that as part of the declaration. But if not, it's a potential rule. It's under a reasonableness standard of, what is the association's objective in making sure that they have a business license? I think that for the association, they're probably wanting to make sure that, that you have occupancy limits are reached and so on. They're not being exceeded. I'm just thinking of the use of it, but I'm sure there's a good reason that you could come up with that could pass muster from a rule and regulation. I would just think that would be better off as a declaration amendment than it would be as a rule. Are finding committees mandatory for HOAs? What if you can't find volunteers from Philip? That's a great question that I get a lot on enforcement. They are mandatory if you want to pass a fine. It's not mandatory to enforce your documents. They're just mandatory in order to actually collect a fine. If you can't find volunteers, then the board would just basically send notices out and eventually send it over to the attorney saying, we've sent you notice of the violation. You haven't corrected it. Therefore, our attorney is going to contact you. And now you take the appropriate enforcement steps, which are arbitration for condos and it's pre-suit mediation for HOAs. So that would be the appropriate step. So just because you can't find doesn't mean that you can't enforce your documents. You are still able to do so. It's just that finding, if it's done properly, is a way to keep it out of sending it to the attorney a lot of times. And people don't like being fined and they come into compliance, or maybe they pay the fine or they reduce it. But if you can't find volunteers, it doesn't mean that you can't fine though. James said, as a board president, can he or she make an executive decision for a particular short-term or minor issue that's not detailed in the rules and regulations? That's a great question, James. It just depends on what a great attorney answer, right? It just depends. I think it just depends, though, on what the issue is, what's provided for in the governing documents, and does it rise to the level of requiring a board vote, or is that within your day-to-day discretion as a president? It's always a good question that you should be asking in terms of what the president can do versus what the board should do. I always recommend, if it's an emergency, for example, boards can call emergency meetings and give practical notice as soon as possible. So if it is a true emergency, then the board can do that. If it's not a true emergency and it's the president, then I would still probably err on the side of, hey, I'd rather not risk my own neck. Why don't I just call a quick 48-hour notice board meeting to approve it? So that's just something you have to weigh into terms of what kind of decision needs to be made. Lisa wants to know, are you required to allow for member input during meetings? The answer is yes. You have to allow them to speak on agenda items for a reasonable period of time. And generally it's 3 minutes, but I would recommend adopting rules to establish that time period. Does a committee meeting have to be noticed if the project and funds were approved during an annual meeting when the budget was approved? That's a good question. If the project and funds are already approved and they're just basically carrying out what was already approved in front of a open board meeting, that's okay. But if the budget was approved, like budgeting for that expense, and now you're deciding how to use that money as a budgeted item, I would still say that that would need to be noticed and open to the membership, because now you're actually showing what you're using that budgeted amount for. If you already approved the project, which it sounds like you did in the contract, and now this is just formally carrying it out, that wouldn't necessarily need to be noticed. But if it's, well, we have the money and the board approved it as a budget item, but now we're actually spending the money, that would need to be noticed to the membership. For a condo, if it's a condo, you already have to, because any committee meetings have to be noticed to the membership. One question, if a small HOA only meets quarterly, an issue comes up between meetings that needs action, are you saying that we cannot vote on taking action that needed an item via email? That seems like that pushes us to more meetings. I agree. It does. That's why you can have meetings with just 48 hours notice. So if there is something that does come up that can't wait, you could call a quick board meeting to address it. That's the thing, because the idea is that if the board's going to be acting on it, the membership should be able to attend and participate in that discussion. If nothing else, then just comment on it and then see how the board interacts there. So Michael said emotional support animals are allowed in a fenced pool area as well. Are they allowed in the actual pool? That's a good question. I know I just talked about them from a health code. I have to check on this. I believe that you don't have to allow them in the actual pool, but you can allow them in the pool fenced in area, but they have to be handled. I don't think that you're allowed to have them in and then just tie them up on a leash so the owner goes swimming. I believe that somebody actually has to handle them. I know that you can prohibit them from anywhere where there's like food service being provided. So that's a good question, Michael, but I believe the answer is you don't have to allow them in the pool, but I believe on the pool deck within a certain area, I think you do have to allow them. Greg says, regarding property insurance, please expand the difference between law and ordinance and replacement cost. So if you have to have replacement cost, that would bring it up to where it was without depreciation. But if you don't have law and ordinance coverage, and Larry kind of expanded on that before, that may just bring it to where it was to build the building to existing to previous code. If you don't have the law and ordinance coverage, you're not getting that additional money to bring it up to whatever the current building code requirements are. So you may be saying, hey, to have our building, I can try to give three numbers. Let's see. Let's say to replacement cost for existing code is $2 million. To replacement cost for previous code is 1.75 million. To actual cash value because of depreciation was 1.5. So you can see the difference that if you have replacement costs but not in law and ordinance, you might get the 1.75 number if I remember the numbers that I gave you, right? But if you have replacement costs and law and ordinance, it would bring you up to the current code without taking into account depreciation there. So that's why I hope I explained the difference there, why you still need to have replacement costs and law and ordinance on top of that. Elliot says a resident's complaining about a smoker on the floor below inside their unit on the screened in patio. Smell drifts into their unit. Is there any recourse? It's a great question. I've had associations that have passed rules regarding smoking on common areas or limited common areas. If you're going to pass that rule regarding inside the unit, it can be more, obviously, that's more sensitive even, that owners may not like that, but I think there's a potential rational basis for it. I would just want to walk through the rulemaking authority, or if you can get a membership vote, that's even better because it's a lot harder to overturn that. Because anything that's voted on by the membership is clothed with a strong presumption of validity. Anything that's done by a board vote as a rule is judged on a reasonableness standard, and it can be a little bit easier to overturn that. So there are ways to do that. We have done it, but I would work with your manager and really with your attorney if you're going to be adopting that and making sure you're going through the appropriate steps. So Gianna, if you can reach out, this is a more specific question. It had a question about grading issues with the common areas and who's responsible with the CDD. That's just going to really depend on the property ownership and maybe what's contained in any, like in the PUD for the planned unit development, and which entity is responsible for what, and reaching out to the CDD. So I can't give you a more specific answer. I think it is more dependent on the community that you live in, and that's a little more fact intensive. Debbie says, when the developer or founder hands the operation to the community, do founders' rights and the declaration stay with the community? It's a good question. So when turnover takes place, there can be an assignment of the declarant rights. Sometimes that may be automatic in the declaration. Sometimes the developer holds on to certain rights, like architecture, to make architectural decisions or retaining certain easements. It's not an automatic that just when turnover takes place and now the association has those rights. It has to be established in the declaration or by way of a written instrument from the developer. And sometimes they'll do that. They'll say, they'll assign it over. So now the association has all of the developer rights. So it is document specific, but it's not uncommon for developers to retain certain rights even after turnover. Steve said, what is a reasonable reserve percentage to keep on hand? I guess it's hard to answer that because the reserve amounts are based upon the fully funded formula from the reserve study that you have and from what the reserve study from the reserve analyst. So from a percentage, if you're saying a percentage of your total operating or what your annual budget is, like how much should be reserves versus the rest, it's just really based upon the funding formula. Chuck wants to know, can a homeowner's dues be waived? That's a great question. You're actually not allowed to do that. The only time where you can make a specific decision as a board is maybe if there's an owner that's delinquent and the property's about to go through foreclosure or bankruptcy, and they make an offer to say, I will pay this in order to avoid this circumstance. And if you don't, then you're likely to receive much less than this offer. I think that the board has the ability to make that decision in the best financial interest. You need to get legal advice so we can tell you if that's actually going to happen or not. But I do think that that is something, it can happen. But by and large, outside of that very limited circumstance, you cannot waive assessments. I think that you have the discretion to potentially waive late fees and interest, again, on an individual basis, depending on the owner's circumstance. But especially waiving assessments, it's very difficult to do aside from, hey, in order for this sale to go through, will you agree to accept 2 years of assessments rather than, 4 or 5 years or whatever to allow the sale to go through? That may be not even necessarily waiving it so much as accepting a lower amount to allow for the sale to go through, but that owner may still have that liability for the unpaid assessment amount. For an HOA election, is there a statute clarifying if advance call for candidates take place? So I think I answered your question there, saying that you have to allow nominations from the floor unless your governing documents provide for a nomination and advance process, and that's for HOAs. For condos, you don't have any way for nominating from the floor. It's all a very specific process for nominating in advance. All right. Yep. Stephen, I think you had asked about getting a copy of the slides. If you can just email Nanny for that, we'll make sure to give everybody a copy of the PowerPoint if you can reach out to us. Reginald wants to know, does the board have to vote on whether a pooled or straight line reserve? That's a great question. If you have straight line reserves and you want to move them into pooled reserves, the way that most attorneys interpret that is that you're having a vote to use the reserves for other than their anticipated purpose, because now you're taking all the different reserve components and putting into one pot of money that you can pull from it. It's still only for those reserve items, but you're technically using money that may have been allocated for another reserve for a different reserve item. So for that one-time change, it's been our recommendation that you have that member vote, which you have to have a majority approval at a meeting where a quorum is met. And that's how you establish the pooled reserves to move the straight line to the pool reserve account. Mike wants to know, do owners have the right to a roster? Is there info that they cannot have? I think I answered some of that as part of the official records, that it's limited that you can have an owner roster and their mailing address and their property address. But beyond that, in terms of what is provided as part of the official records, owners have to consent to have that included. James says, I like your suggestion from the past that a board member have a separate email address for board business. Absolutely. I meant to bring that up today. Having that, then you're kind of training yourself to only use that for board business, so that if you ever have to make those emails available, you're not providing your separate email address that you use for all your other private stuff. And then you can turn it over to a new board member whenever they come in. And then that way you have kind of like a archive. You can see some of the old emails, and there's like some institutional knowledge there, for lack of a better term. Philip wants to know, can the website be a private group on Facebook? I believe I have to look at the website requirements again. I think it has to be something that's hosted that the association's in control of. So I don't think that just by hosting it on Facebook that you have full control over that. I think you have your own separate website that the association has control over, that it maintains. So again, I guess that could be management, but as long as the association is the decision-making authority and has access to it. So I just would be careful about trying to do that all through Facebook. I think it has to be actually hosted in an actual website by the association and not just a Facebook group. Is there a limit as to how large a deductible or how much risk a condo association may choose to retain? It's a great question, and that's just part of the business judgment, the board making good decisions to make sure. I'd have to look at that a little bit more. I don't believe that there's anything as to a maximum deductible amount that the association may have. I'd have to look at that further for you, but that's a great question as part of the decision-making process for the association of, hey, how much are we really saving here by having such a high deductible that if we actually have an insurable event, that we're going to have to meet this deductible and the impact that it's going to have on our membership. So it's a great question. Stephen wants to know, does the emotional support animal documentation have to be updated every year? If that means by the person requesting it, the answer is no, that their authorization holds for as long as they own the unit, or property, but if they move out or something, or if there's a change, that needs to be submitted. It doesn't carry over to a new owner or to another family member. All right, I'm going to try to answer. I know we're going here, so if we can, I'll just answer the last couple questions here. In the HOA where a resident is making a renovation approved by the architectural committee, can you require a copy of the building permit? I think I had answered that previously when I was answering questions there. I think that you can require that a copy of the building permit just to show that they're going through the appropriate process, because it's likely, oh, this is for an HOA. Okay, not for a condo. I still think it's reasonable to ask for a copy of the building permit to make sure that that's done properly, make sure that all the requirements for the local county or municipality have been met. So Rosa had asked, can you clarify about HOA restrictions on rentals and others like B&B? So right now, there's nothing in place that prohibits an HOA from limiting short-term rentals and having, minimum 1-year rental periods. And that even if the amendment passes with some owners objecting to it, it would apply to everybody. There may be a statutory change down the road that changes that right now to make it more like condos, where you can maybe put that in place, but it's only applicable to those who vote in favor of the amendment and then future owners. So you're kind of having a grandfather provision. But for right now, for HOAs, there's no restrictions on that. So you could, as long as the amendment passed, it would apply to everybody immediately. There's no retroactive, or grandfathering or anything. John says, we've had trouble getting quorum on our HOA due to an inactive board for years. Any suggestions on attracting interest and participation? Yes, one thing I think would be is really consider going to electronic voting. That just helps you make quorum a lot easier. I've had some larger communities that have done that, and they were finally able to have an annual meeting where in past instances they weren't able to do it because people didn't care enough to show up or submit their proxy. So I think the biggest thing is really electronic voting. That would be the best recommendation that I would have. Robert says, if a majority of the board members are newly elected, should an audit be requested of financials to protect the new officers? I don't know that that's required. I think you take a look and just get your hands on the existing financials, see what the financial reporting requirements are. If you have reason to be concerned, you can always choose to have an audit. You're just not required to do it. Is there a definition of a proper support animal? I just had that in one of the slides where it basically says that it's an animal that alleviates or ameliorates the effect of a disability, basically. So now that doesn't mean that if it's one that poses a clear danger, like if you have a pet tiger, for example, like that would not be a proper emotional support animal. But I've seen instances of people requesting kangaroos, potbelly pigs, all kinds of different support animals that maybe aren't inherently dangerous, but aren't your typical type of animals. I've seen them prescribed. So it still is up to the treating healthcare provider to say that that animal is necessary. So you don't have a very clear definition. There's no training required. So there's a question here about, is there a percentage of the budget that is needed for your reserves? No, it's not based on your total budget amount so much as it is just what your components are, that you're properly funding them for the reserves or the components that you do have to reserve for. There's no minimum requirement that says that your reserves need to make up at least 20% of your total budget, for example. One question, this is a good one, is adding pickleball lines to a tennis court with no other changes typically a board decision or a vote of the owners? That is a great question as to whether or not that's a material alteration of the common elements. I don't know that that would be considered a material alteration. If you are, can you still keep the tennis court lines in place? And if you can still use it as a tennis court, I could see that especially being okay. If you're changing it from a tennis court to a pickleball court, I could see that potentially requiring a board vote. I'm not aware if there's been a arbitration decision on that, but that's a great question. It's one that somebody could challenge. If they were to challenge you on it by saying that that required a membership vote, they would have to send you a pre-arbitration demand and give you a reasonable opportunity to correct it. And maybe you do it and then wait for that. And this is more of a practical thing than anything else. And then you could choose to then correct it back to the tennis court if somebody felt that strongly about it and you got an opinion from your attorney. Maybe you didn't get your opinion first, but now you're seeking our advice. That may be one way to handle it, but it's a good question of one. Obviously, the conservative thing is to have a vote of the membership to avoid any potential challenge, but it's a great question. Gianna says committees in regards to paint colors and design do not have more authority than the board. Correct. The board has final decision in that. The committee is just to provide it just depends on how your architectural committee is set up. A lot of times architectural committees are set up where they have decision-making authority and they have guidelines. So you really want to, if you want to have board have final authority, you need to make sure that your documents provide for that so that there's not any question between who makes the final decision on it. And you don't want to have the committee telling the owner that this is approved when, if the board has final say-so or whatever. If that's the case, you could say, hey, it's met our approval, but it's still now going to the board for its final decision-making authority. If that's the way your process is, then at least that member knows that they need to wait for the final decision from the board. But you just want to be clear on what your process is and what your documents allow for. All right, and the last question. If an amendment passes and an owner did not vote, are they immediately subject to pass amendment? It's a great question. It just depends on what the amendment is and how you word it. The main one that comes to mind is the condo amendment on the rental change, that even if it only applies to you if you vote in favor of it, and then to anybody that owns you once you sell your unit. Aside from that, any other amendments largely are retroactive. It may depend on if there's contractual issues that are in play, and we'd have to advise. And usually I would help advise associations on that and say, hey, when you pass this amendment, you need to get a list of people. And maybe there's, maybe there's a certain period that they're grandfathered in. It just depends on the amendment change. But by and large, it's retroactive unless the statute provides for, like the condo rental change. That would be one that's clearly only for those going forward and who voted in favor of it. All right. Well, thank you all very much. I'm getting you out of here before noon. Again, here's our contact information. For all of our clients in here, thank you for allowing us to provide legal services for you. If you haven't worked with us, please feel free to reach out. But I enjoy providing these presentations. We will certainly be providing a legal update. If you go to our website on flcalegal.com, if you scroll down, you can actually make sure that you subscribe to receive emails. So if you were forwarded our information for today, you can make sure that you receive it directly in the future, or feel free to email myself or Nanny. We'll make sure to add you to the list. But otherwise, thank you all for attending. Have a great weekend, and I'm sure we'll be in touch soon.